laws of Florida within the Commonwealth. Draw near, leave your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Please be seated. Good morning, Your Honors.
Morning.
Morning. Good morning. Welcome to the Appeals Court. I'm William Meade. To my right is Justice Walsh, and to my left is Justice D'Angelo. We will be the panel for all of the arguments today. If you haven't been here before, we've read everything. Each side gets 15 minutes. You needn't use all of your time. There's no shame in sitting down when the green light's still on. We do not entertain rebuttal. And with that, I'll get to our first case. 23P989, Commonwealth versus Cologne. Ms. Howe.
Good morning. May it please the court. Attorney Caroline Howe on behalf of Mr. DAPENA Cologne. This is a case about the erroneous denial of a peremptory challenge.
Ms. Howe, can you move the microphone? There you go.
Is this better?
That's better, yeah.
The problem in this case is that the judge never gave defense counsel any information about which impanelment method he was going to be using. And the problem with not his failure to tell counsel which method he was going to be employing is that under the new district court standing order, there are now 4 different impanelment methods for district court judges to choose from. I would like to quickly highlight 3 points for the court. The first.
Before you highlight those 3 points, can I just ask,
Yeah.
do you agree or to the extent concede that the method that the judge used was appropriate?
I think had he explained his method, it would have been
Just
appropriate.
the method itself?
I think his method was confusing, and that's because when there were 7 jurors that were seated and defense counsel exercised his peremptory challenge on juror number 3, the judge didn't then return to defense counsel and ask him, are you content with the remaining jurors? Instead, a new juror was brought forward, found indifferent, and then the judge asked, and I think his exact phrasing is important, he asked, is the defendant content? He didn't say, is the defendant content with the remaining jurors? Is the defendant content with this specific juror? Is the defendant content so far?
So I
It was
just
very
want to make sure I
open-ended.
understand your argument. You're not conceding that the judge properly utilized one of the 4 different methods for impaneling a jury?
Had the judge explained his method prior to voir dire, I think that defense counsel would have been on notice about what he was responsible for doing and how and exercising a timely peremptory challenge. But because there was no explanation and because there was confusion within the method, I think both of those things contributed to defense counsel not being able to.
Wouldn't it become immediately apparent what was going on, though? I mean, the jury box is full. He didn't say, are you content with this juror? He said, are you content with the jury?
Well, actually, according to the transcript, the judge said, is the defendant content?
Okay.
And so he didn't ask, are you content?
Was the jury box full?
The jury box was full with the replacement juror. So they had just finished asking whether he was, whether that indifferent juror, but they had just finished voir diring that juror, finding him indifferent, and then asking, is the defendant content? So again, had he had said, are you content with the entire jury, then I think that would have clarified the confusion. But again, because there are all these different impanelment methods, one of which is full comparative choice, in which, the defendant has the opportunity to see everybody who's, been found indifferent before striking, I think all of these different methods are so, they require explanation. And Commonwealth
What was he content with then?
I think he could have been content with that specific juror. He could have been content so far. But the prohibition on going...
Challenges are done at sidebar, right?
I think in this case they were,
Yeah,
but they're not always.
So if he was speaking to a specific juror, that would have occurred at sidebar.
I believe so.
So when he said he was content, he was not at sidebar.
I don't think it's clear from the transcript where they were. But I think Commonwealth v. Hines, which is a 2021 SJC case, makes it very clear that it's for the judge to be clarifying to counsel which impanelment method they're to be using. And Commonwealth v. Hines is happening after the new Rule 6 under the Superior Court, the new district court standing order. And in that case, the judge explained his impanelment once prior to trial, and then he explained his impanelment method halfway through to clarify to counsel where they were. And the SJC said that's sufficient, but even still, it could have been even clearer and dropped a footnote saying this is exactly what could have clarified defense counsel's confusion. And in Commonwealth v. Hines, they say Rule 20 provides this window from when a juror is found indifferent to when the jury is sworn, and that's a big window. And within that window, citing to Rule 6, the trial judge has discretion to choose any of those methods, provided in Rule 6 because Hines was a Superior Court case, but because we're in the district court, it would have been one of the 4 methods in the district court standing order.
Can we draw any inference that the judge at the very beginning basically says to defense counsel, you've appeared before me many times, you know my system? Can we infer anything from that during the impanelment it was the same as what the judge had used in the past, or adversely, this was different than how he had done it in the past?
I don't think it says explicitly in the transcript whether he had appeared in front of this judge. He says, I know Mr. King knows the jury impanelment process. I don't think it's clear that he knows this judge's impanelment process, but the district court standing order now gives judges permission and discretion to change even between jury trials which impanelment method they're using. So the fact that this judge is using this impanelment method here doesn't mean that he's done so previously, and he certainly has discretion to change. And district court practice is very fast-paced. People are appearing in front of lots of different judges all the time. So that's why, clarifying for counsel ahead of voir dire is so important.
Well, I mean, we wouldn't be here, right, if the judge clarified. So I'm not going to argue with your proposition that it would have been excellent practice for the judge to clarify. But that being said, we're not dealing with pro se individuals. We're dealing with experienced attorneys who the record at least reflects some statement that that particular attorney had been practicing and impaneled. And so the standing order doesn't require a judge to explain which of the 4 methods he or she is employing. And I understand the Hines case, Superior Court case, talks about the importance in the role of the judge, but it doesn't let the attorney off the hook to say, Judge, before we begin, which one of these 4 methods so that I know how to challenge and use a peremptory challenge? And then I guess my second question is, so one is we rest all the fault on the judge. Okay. Secondly, even if the judge did that, where's the prejudice other than your client got found guilty? I mean, I'm having a difficult time understanding, even if he was prohibited from exercising a peremptory challenge that he ought to have had. Where's the harm?
So I can address your first point, firstly, about whether it was on the attorney to clarify for the court. So I want to focus on what counsel knew going into voir dire. So the clerk, prior to voir dire, on page 33 of the transcript, tells the defendant, if you should object to any of the jurors, you will do so after their numbers are called and before they are sworn. And that sounds very similar to Rule 20, once a juror is found indifferent and before the jury is sworn. But that's it. And I think that had defense counsel, again, had information ahead of time, as Hines, I think, suggests that is necessary, that judges have the discretion to further designate that the judge must set the parameters under which defense counsel should be exercising his peremptory challenges. But again, because of the fact that the judge was inconsistent even within his own method, I think that further threw defense counsel off and further added confusion. In terms of prejudice, there's a longstanding rule under the SJC precedent and under this court's precedent that no prejudice is required where there's an erroneous denial of a peremptory challenge. And that's been the case as long as GLC 23A Section 74 has been enacted, and that's certainly been true post-2016. I know the Commonwealth in their brief made an argument that Section 32 was repealed in 2016, but in my reply brief I cite several cases from this court, from the SJC, that clarify that this is still the case, this is still the rule, that no prejudice is required, and there's a very good reason for that rule.
If we don't presume prejudice, can you make a showing?
Well, I don't think that I have to. And
I understand that. If we don't presume prejudice, can you make a showing?
I don't think under this record, and it's because a showing of prejudice in this situation is impossible. As the SJC has reasoned many times, you can never know how a properly designated jury would decide the case. You can never peer behind the secrecy of jury deliberations and understand whether that juror who you supposed was hiding a bias actually was hiding that same bias. And because of that impossibility, a showing of prejudice is never required in the circumstance.
Going back to the first part, was there ever in place by rule or statute or case law that would allow peremptory challenges to go back and exercise one that had foregone prior?
So one of the methods under the new district court standing order is that once the juror has been found indifferent, peremptory challenges can be exercised at any time. And so I think that is so open-ended that it is conceivable under that method.
As poorly framed as my question was, what I was really wanted to focus on is, yes, that is one that you can do it at any time until they're sworn, but is there an accepted method where you can go back and retroactively exercise one on a juror that you did not exercise at a proper time?
Under the former Rule 6 of the Superior Court, there was a very strict prohibition on going back. I don't think that there was a similar rule in the district court as far as I could tell, but that was the rule for a very long time, and it's a very, I think, ingrained part of our practice. But I don't think that prohibition exists under the plain language of the district court standing order as it stands. So I think in this situation...
So there's no rule or practice or case that expressly says that what the defense counsel did here was proper?
I don't think so, but I also think that's because a lot of the old case law is under the former Superior Court Rule 6 where this was explicitly prohibited.
Well, I mean, a lot of our docket comes from the district court, as we all know. We're here.
Yeah, but I think this is a very unusual circumstance where you have a judge not explaining the peremptory challenge method, and then you also have this very open-ended question: is the defendant content? And we don't know what he's asking.
Do you think it would make a difference if he said, I'm content as to that juror, versus I'm content?
I think as soon as defense counsel realized there was a miscommunication, he was objecting, and he was clarifying for the judge that he had a problem and that he did not mean to pass on that juror. So I think at any earlier time, he would have been able to, had he known there was this miscommunication, he would have obviously objected, and he objects many times throughout the record as soon as he realizes there was this breakdown in communication. So I think, again, as Commonwealth v. Hines really places on the judge this emphasis on you need to be explaining to counsel what your impanelment method is, because there are all these options now. It's not the former Superior Court Rule 6 where there was one way of doing it, one strict way. There are all these different ways now.
Well, there are 4 ways that the standing order gives guidance to attorneys. None of those 4 ways say you can go back. And after challenging only one individual juror, and then go back and challenge any of them, correct?
Right, and I think had the judge clarified that was his practice, I think defense counsel would have been on notice.
Not the judge's practice, but of those 4 possibilities in the standing order, as Justice Meade has just asked, and I think I have the answer that you gave correctly, there's no stamped, approved method of what defense counsel was trying to do in returning back to the beginning.
I think prior to the new district court standing order, there's only one case that's been decided since the district court standing order that has mentioned it, but prior to then, there was no rule in the district court about what or when people should be using peremptory challenges. So I think that it's hard to say that there was a rule prohibiting going back in the district court, because I don't think that rule existed, and I don't think that rule exists now under the plain language of the district court standing order. I don't think there is a prohibition on going back explicitly, but I think a judge can make that clear very easily to defense counsel and to the Commonwealth prior to voir dire. If there are no further questions, I would ask that you reverse Mr. DAPENA-Cologne's conviction. Thank you.
Mr. Lee.
May it please the court. ADHE Chile from Middlesex on behalf of the Commonwealth. Rule 20 does allow peremptory challenge to be made before the jurors were sworn, but judges have large degree of discretion in jury selection. This case is not about the timing of the peremptory challenge method under the standing order. This is not a case where there's a confusion of the challenge should be made after the box were full or should be done one by one as the jury were filling the box. This is when a defense counsel had answered content with a jury that consists of jury number 6, and then retroactively trying to challenge that juror.
Let's assume that is exactly what defense counsel did, that he went back and he said, oh, I actually don't like that one. Do you agree that defense counsel technically to the letter complied with the wording of the statute and the district court order? And if not, how?
So the district order does not talk about the practice of content. That's true, but in Zaka's 1970 case from the SJC, the court found that the failure seasonably to object to using the preemptive challenge was the waiver of the right to object.
So how do we know what seasonably?
I'm sorry.
How do we know what seasonably means if the judge doesn't explain to the lawyer what that means?
So the word content doesn't really require explanation. At that point, you either contend with the jury or you exercise a challenge. There's no other option. This is not a time where you should make a preemptive challenge at the beginning of the selection or at the end of the selection. It is not a case about timing. It is about a specific word, content, a word widely commonly used in the jury selection process. And as Justice D'Angelo pointed out earlier, the record shows that Attorney King knows the jury selection process, and he's...
Mr. Lee, I saw how old Zachus was, and it piqued my curiosity, so I read it this morning. And this challenge was exercised after the jury was sworn.
That is correct, but Zachus...
And that's what made it untimely.
That is true, but Zachus also just talks about in general. And if you look at Barnes, the attorney in that case specifically asked to withdraw satisfaction of a lay preemptive challenge because he was worried about it would become a waiver. So this is a practice that's commonly accepted in the Commonwealth. If you use the word content, that means you're happy with the jury. This is not a case where there's only 2 jurors in and the judge asks if you're content. If that's the case, I agree with my friend on the other side. There should be some explanations as to the process. This is a case where 7 jurors were filled into the jury box, and the defense attorney affirmed that he was content after he asked for some time.
Back to my question, counsel.
Yes, Your Honor.
One of the district court standing order, I don't want to say rule, but options is that a peremptory can be exercised prior to the jurors being sworn in. There's nothing about word content. So did defense counsel comply with that option in the standing order?
So it's consistent with the option. However, the judge has large latitude in jury selection, and the word content.
I agree with you. But if the defense counsel doesn't know what process the judge is using, how is defense counsel supposed to know that? So
if this is a new attorney, this is his first trial, I agree there should be a record developed in a motion for new trial. Maybe that would be a case to overturn a conviction based on this error. This is an attorney who understands the jury selection process based on the record. So on this record, the word content carries its weight. The defense attorney understands the process, and he was content with the jury consisting of juror number 6. And this, because there was no error, this court need not reach the prejudice versus structural error question. But if this court reaches that question, Chapter 234A, Section 74 governs this case for 3 reasons. Number 1, the SJC's general proposition must be read in context. Number 2, Section 74 is a limitation on judicial power to set aside a verdict based on a statutory right. Without a constitutional error, neither this court nor the SJC has authority to ignore Section 74 without violating the superior powers.
How can defense counsel in such a situation ever show error? Ever?
Defense
Give me an
attorney
example.
could interview the jurors afterwards. I understand it's difficult, but it is not for the judiciary to ignore Section 74 because this is not a constitutional right. This is not an error with a constitutional challenge demand. And this court has recognized there's a difference between non-constitutional and constitutional jury selection error. In this court in Barati's 115 case, 88 Mass Appeals Court 466, Justice Walsh, writing for the majority, held that the mistaken denial of preemptive challenge is not per se structural error under the federal law. Justice Walsh, writing for this court, also said, nor have we held that it is structural error under Article 12. In that case, the defendant was only given 5 peremptory instead of 13 that was entitled to. So that is a perfect case for this court because in that case, this court did not hold that it was a structural error that the defendant was denied 8 peremptory challenges. This court recognizes this difference between constitutional and non-constitutional.
Can you follow through with what you just said? First of all, 74 was written prior to allowing lawyers to contact jurors. You agree with that, correct?
Yes.
Okay. Now let's follow through. So defense counsel hires an investigator or him or herself goes and interviews jurors. What does he or she need to show prejudice here? Is it that juror that he wanted to exercise a peremptory? What does he have to show?
I think in this specific case, you will have some bias that would really go into the striking for cause. And if there's, for example, if a case where the judge failed to strike a juror for cause and a defendant was forced to use peremptory, that could be a reason to show prejudice. I understand it is difficult, if not impossible, to show prejudice, but that alone is not enough to get to structural error. It's a constitutional
Can I
demand.
interrupt for a moment? If your argument is that in order to succeed, the defendant has to show that there was prejudice suffered as a result of the failure to exercise a peremptory challenge, it has to have a meaning, right? It has to be a meaningful right. And if we're to accept that, you've just explained to Justice D'Angelo that really it's for cause, it's bias. But if you have a right to peremptory challenges, then there has to be a meaningful right. And if you have to show prejudice, there has to be an ability under peremptory. Think of what peremptory is. It's not for cause, it's not bias, I just don't think you'll be a good fit, right?
I understand it is
How
difficult.
does that rise to a level of prejudice?
But the legislature has a demand of prejudice. It is not for this court to decide. I agree, without Section 74, this court, SJC, are free to adopt a structural error standard.
What about Hampton and Green, where the court says you don't have to show prejudice?
So Hampton simply reiterated its just general proposition. And if you look at Commonwealth v. Emerald's 1987 case on SJC 399-617, the court say, if the remedy of a new trial is not available for violation of the constitutional right to an impartial juror because of juror misconduct, unless the court finds that a juror was actually or impliedly prejudiced, it cannot follow that a denial of a non-constitutional right involving jury selection is reversible error without a showing of prejudice. So the SJC recognizes the difference between constitutional and non-constitutional error. My friend on the other side cited Commonwealth v. Green, footnote 6, talking about Emerald case. But Commonwealth Green was about Batson-Soros. This case is not about Batson-Soros. It's simply a denial of parental challenge without a constitutional error.
You were writing this opinion. What is the definition of prejudice you would give to practitioners? Because everything you've said so far, it's irrelevant whether it was a peremptory challenge. If a defense lawyer goes and interviews a juror and shows bias, that's no matter what. If there's extraneous circumstances that come into the jury, that's under every case. So what does prejudice mean in the context of a peremptory challenge?
I would say this court can allow the case to develop. For example, in Commonwealth v. Walsh 2016 case, the SJC abolished or limited substantially of Downs instruction. In that case, the court opened up a possibility of Downs instruction to say in extraordinary circumstances. But SJC also said they could not imagine there could be one. But this court later in DeRozier and Marino had found there was that extraordinary circumstances in these two cases. So even though the SJC had in 2016 found it was impossible to have that case, later this court actually found that one case 8 or 7 years later.
This time today, prejudice means nothing. We have to wait for another case to
Not in this case, because there was no record to show prejudice, and that is required under Section 74, that this court cannot ignore, because there's nothing constitutional in this case. And without a constitutional error, this court must abide by Section 74, a limitation on judicial power.
Almost, would you agree with me that your first argument may be stronger than your second?
I agree, yes, because it's a clearer issue.
In all seriousness, do you have any cases, now I understand that the word "I'm content," there may not be a published case about what effect that has, but do you have any analogous cases in which an attorney, in essence, waived any further argument, either agreed and stipulated or something of that nature that you would say is a similar set of facts that binds counsel to their words?
So there's nothing specific that I could find. So what I could find, which is cited in the brief, is Zacchaeus, Barnes, and Mason. If you look at Mason, in that case, the defendant was answered content. The defendant answered content, and then the parental challenge was raised by the Commonwealth after the jury was seated because there was new information surfaced. So in this situation, if you look at these three cases, there's a clear pattern from this court and this JC that the word content means something. And that means that if you answer content, you have remaining preemptory challenges. That means it's a waiver.
Unless you learn new information.
Exactly. So it's not a complete bar. It's a, if after you waive a right, unless something has changed, you should be bound by the word that you provided to the court. If there are no further questions, the Commonwealth response brief.
Thank you. Thank you both. Well done. Our next case is 23P505, Commonwealth versus DELANA. Oops. Yeah. Mr. Pomelo.
Yes, good morning, Your Honors. May it please this honorable court. Todd Pomelo on behalf of Mr. Marcos DELANA. This court should reverse the denial of his motion to vacate and remand for an evidentiary hearing because the case law requires it. This is a circumstance where the docket sheet only reflects that an attorney named Glenn represented my client in 2001. During a time frame where the precedent established by this court in Commonwealth versus Frere was that immigration was merely a collateral issue, and defense counsel need not give any advice whatsoever under the Sixth Amendment to the U.S. Constitution. We attempt to get an affidavit from the attorney.
I'm sorry, Mr. Pomelo, the docket says guilty plea or admission to sufficient facts accepted after colloquy and 29D warning.
Correct.
It doesn't just say he was represented by Mr. Glenn.
That's a separate section of the docket sheet you're referring to, Your Honor. The upper right-hand corner of the docket sheet says Glenn. To the left of it, there's another name crossed out where that attorney was bail only. That has a first name and a last name of Felix. Whereas where it says Attorney Glenn, it doesn't say a first or a last name. We were able to determine there were two Attorney Glenns that practiced in that court as bar advocates for numerous years. One of them was apparently 88 years old. So when we speak to the attorney to get an affidavit, he didn't have his file, which wasn't surprising. He had no memory of the particular client. And we were trying to figure out what advice would you have given back then, given the landscape at the time? And the answer we got would have went over basically what was on the green sheet. That's the May warning that does not substitute for advice of counsel. When trying to get an affidavit, we could not get an affidavit. It was during the pandemic, so we had to do the hearing. It was by Zoom. And based on that backdrop, we respectfully told the court that we should, at a minimum, be entitled to an evidentiary hearing on that purpose. We don't have authority to issue a subpoena, only the judge does. And we have to have an evidentiary hearing before subpoenaing any witness. We didn't get an evidentiary hearing at all on that point. We filed a motion to reconsider. Before doing so, we contacted the office. The secretary claimed that it was the older Attorney Glenn, who was 88, he didn't have much of a memory. Practically, we weren't able to effectively get an affidavit from either attorney. It's not even clear to us who represented him, but we know an Attorney Glenn represented him.
That's why it's important not to wait 18 years to bring these motions.
Because he was only deported recently.
But, okay, so the presumption comes into play, right? That he got the warning because the docket reflects it.
Well, not necessarily. There's a recent case, I think it's John Louis cited in our brief from 2023, that says that that is not necessarily dispositive.
You cited to that footnote, but you left out the sentence after that said the judge can consider it in his discretion.
Judge can in his discretion, and that's ordinarily where the judge is the plea judge who handled the plea. This judge has just been deceased since 2015. And respectfully, the Commonwealth's argument at the hearing, it conceded it couldn't meet its burden and was trying to rely on the presumption of regularity, blaming the defendant for that record not existing because it was destroyed. It's the Commonwealth's burden to hold on to these records under the 29D analysis. That's separate and apart from that under Rule 30B. 30B is a different legal standard. But respectfully, it's not necessarily dispositive, but the old docket sheets had separate boxes that would be checked in addition to a colloquy. So this is an issue where every time a colloquy is conducted, if an immigration warning isn't given, do you check the box or not? The box is checked, it presumes the warning was given, but it may not have been given. If it's not checked, it presumes no colloquy happened, even though the records would reflect otherwise. And that's, again, a basis for an evidentiary hearing. But regarding the Padilla claim, like, back then, lawyers didn't have to give this advice. In 2010, Padilla came out, March 31st. The Sylvain case, then there was Clark that held that Padilla was retroactive, and then in 2012, Chidas held that Padilla was not retroactive, and then in 2013, Sylvain made Padilla retroactive under state constitutional law. Back when my client had pleaded, the notice to appear attached to the motion as an exhibit states his inmate number, states that he was served it while he was in pretrial detention in the Plymouth County House of Correction, where he ultimately served his 4-month sentence. He wasn't deported at that time. The federal government did not seek removal. So what does he do? He establishes his life. He has a thriving construction business. He gets married. He's raising 5 stepchildren. He's not living on the lam. You see a lot of cases where people get an alias and they live in, they move far away. They don't live an open and free life. There's all these photographs.
Counsel, you're getting into the special circumstances, so let me ask a question about that. Can the strength of a Commonwealth's case be so strong in a case that it overcomes all special circumstances a defendant might have?
I don't believe it can always surmount to that. If you look at the leading case from the U.S. Supreme Court, there's only 3 cases on this Padilla line, if you will. This Padilla itself, that's prong 1, deficient performance. I think deficient performance here, even without an affidavit, can be clearly established in light of the case law. The Frere case says defense counsel need not give this advice. That's mentioned in a footnote as merely being a rescript decision in the Sylvain decision. Sylvain says for the first time we are going to rule that Padilla rights are retroactive to April 1st, 1997. So that's a few years before this plea took place.
Doesn't the strength of a Commonwealth's case also dictate sometimes what a defendant might do in weighing whether to go to trial or not? For example, if the case is so strong and his lawyer says, if you go to trial on this judge is going to put you in jail likely for 2.5 years. But the Commonwealth has offered you 1 year in the House of Correction.
Right.
A defendant might say, you know what, if I go to jail for 2.5 years, I'm definitely getting deported, but if it's only a year, I might not. So doesn't that play into this equation at all?
It plays into it, but if I could just make 2 points. That's assuming you were giving advice in the first place, which we don't concede he was ever given. In order to adequately make that type of determination as to whether throwing a Hail Mary's chance at trial would be worth it given the circumstances of possibly going to prison. This is the J. Lee case. That was the 3rd of the Padilla trifecta from the U.S. Supreme Court. So you have prong 1 is Padilla. Chides says Padilla is not retroactive as a matter of federal law. But the next case is J. Lee. So J. Lee lives in Tennessee. He owns Chinese restaurants, has his residency. He's selling drugs out of his restaurants to undercover police officers. There's confidential informants. He gets arrested. He waives Miranda. They find all the drugs. He gets 1 year and 1 day in jail in the federal court system. And the U.S. Supreme Court said on those facts, how important was immigration to him? They weren't going to substitute their judgment for that of the defendant. And respectfully, I think the J. Lee case is incorporating a subjective intent, whereas the Massachusetts precedent seems to be talking about reasonable probability from the objective standpoint of would a reasonable defendant in these circumstances reject the plea and go to trial. As the J. Lee case explains, you can't tell what would have happened at a trial that never occurred. That's not the issue. The issue is that you're never given the advice, and if you were properly given the advice, would you reject the plea given the special circumstance you would place on permanent deportation from the country? My client, the Commonwealth below, talked about all the evidence that was given after the fact and how that doesn't really amount to special circumstance. There's 2 primary reasons why that information is given. First of all, I think it suggests the detrimental reliance on the lack of advice, the way he goes about living his life. He rebuilds his life. He doesn't get in trouble anymore. He establishes a business. He adopts 5 children. He raises them as his own.
Can I ask you
this?
Don't we measure special circumstances that would have existed at the time that he accepted the plea?
You do, but for example, let's say a special circumstance is you're 15 years old and you want to be a police officer one day. You're not old enough to be a police officer. You get in trouble in the juvenile court system. There was a recent case, Your Honor was on the panel, that the Tarrantino decision decided on May 24th. It's actually not part of our brief, but the citation is 22P 1081. That case was a juvenile who had a juvenile delinquency disposition that affected his ability to remain in the United States. I think when you're looking at a special circumstance, they're not always fully developed at the time. Like, you might have a bona fide desire to be a father, but you haven't impregnated somebody yet. But then you get married and you raise children, and years later you realize you're getting permanently deported from the country. I think those are the circumstances here.
Can I roll the clock back?
Yes,
Quite a
Your Honor.
bit. To me, we first start with two claims that you make. One about 29D, right? And the second about ineffective assistance of counsel.
Yes.
One that was dealt with by the original motion for a new trial and was denied by the judge. And the second that was denied in the motion for reconsideration. When it comes to the issue of ineffective assistance of counsel, let me start by first saying, right, you agree with me that it's your burden of at least providing the court with some degree of evidence that would warrant a hearing.
Yes.
Right? And so, first of all, the way that I look at it is your argument is we don't even know who the attorney is who represented my client, which isn't really carrying the football over into the end zone. But I have to say, first of all, the docket is clear. On docket 2744, entry date 10/25/01, attorney John Glynn appointed. That's son, not father. And the judge relied upon that docket of Attorney Glynn along with your affidavit saying Attorney John Glynn had no memory, but this is what he would do in these circumstances, to say no evidentiary hearing is required. Attorney John Glynn is the attorney for the record, and I'm relying upon the record, which to me, at first blush, seems reasonable to rely upon the docket reflecting the first and last name of the attorney who were representing your client, along with your affidavit saying the attorney doesn't have the files, doesn't have any memory, but here's what he or she did, and this is ineffective. Secondly, the judge found it wasn't ineffective, and even if it also found that it wasn't prejudicial, because your client, the immigration warnings notice, indicated that the reason for deportation did not mention this conviction. It mentioned the fact that he entered the country illegally. So I want to address that issue. And then the second issue with 29D is that the case law appears to be clear that docket entries can be relied upon. And in this instance, you bear the burden of showing irregularity. Commonwealth has to show regularity, and they've met the burden with the checkoff box that says the warnings were given, plea colloquy was given, the guilty plea accepted. And I don't see what you have to rebut that. So if we could first start with the first issue of ineffective assistance of counsel when staring at the docket that says Attorney John Glynn represented your client.
Well, there's a couple of points with the Attorney Glynn. The upper right-hand corner of the handwritten docket we have just has the word Glynn. But then
There's several instances in dockets when attorneys leave, come back, whatever, but
Correct.
we have Attorney John Glynn, clear as
Right.
daylight.
And when we try to obtain an affidavit from him, we are told that I don't remember the case, I don't have my file anymore, I will go to the clerk's office, I'll review their file, I'll get back to you. Silence.
Do you think it was error by the judge in not crediting the docket that says Attorney John Glynn, but in failing to credit hearsay testimony of a secretary who says, oh no, it was the elder Attorney Glynn, and we're not going to let you talk to him?
Well, the issue, respectfully, Your Honor, is you have the law firm not claiming ownership over who represented him.
No,
My
but-
client can't be beholden to whether he gets an affidavit from prior counsel or not. The case law is clear, and I think in these
It
circumstances,
was error for the judge to rely upon the docket that clearly indicates Attorney John Glynn represented your client.
I don't believe it's error for her to rely on it. It's error for her not to subpoena him or his father for an evidentiary hearing because we couldn't obtain his affidavit to fill in more gaps in this case. All we're told is I don't...
More than there's plenty of cases in which we just have an affidavit from a client, correct?
Correct, and here you don't. You have an affidavit from him, you have an affidavit from me based on my efforts, and the case law says that we have to go through these efforts. Commonwealth versus List, you have to go through the efforts to try to get an attorney to provide an affidavit. And if you can't get an affidavit, you have to rely on the motion judge to subpoena him or her to testify. And that's the situation here. We can't get an affidavit. The time is of the essence. We spent a lot of time doing this. It's the heart of the pandemic. We asked the court, there's ambiguity. Can we have him brought in for an evidentiary hearing? The case law at the time, he would not have, what he's saying I don't think is uncommon, that it would have went over the green sheet, but the case law rejects that as the giving of advice. It's not. So that satisfies deficient performance, yet the judge said it did not. Then the Commonwealth concedes in its brief before this court that it did satisfy deficient performance. And then below, regarding the 29D argument, it concedes that it could not rebut the presumption and then relies on the Lopez case, which was not an immigration warnings case. So I think the Commonwealth has conceded some of these issues before the motion judge, and she should have relied on those concessions in allowing the motion under 29D alone.
Let me ask you this before we're out of time.
Sure.
Why don't you have a problem under Granum and Casimir, a wonderful case from this court, that says you can't base your argument on hypothetical circumstances? In other words, your Mr. DELANA was deported for being here illegally, and it did not relate to his conviction here at all.
Permission to answer?
You may.
So there's Graham, Berthold, and the Vasquez case, and several cases, and the client's affidavit about how his wife is petitioning for him to get residency, which is under the exclusion from admission prong. We cite the Kurzban treatise in our brief. He's permanently excludable from admission to the United States, a consequence he is currently suffering because his wife is currently trying to petition for him to come back to the United States. Some people that get deported are allowed to come back through a consular process and a discretionary waiver. That's why that argument was never made years ago by him. And it's not his fault that the records are destroyed, because the burden should lie with the Commonwealth to provide the affirmative evidence that all 3 warnings were orally administered by Judge O'Neill, who is now deceased.
There's something in the record that says he's permanently excluded.
It's in the citations in the brief to all the authority that makes him
I meant for
excludable.
Mr. DELANA, there's something in his record before this court that says he's permanently excluded.
The citation of the case law, which is all it's, I mean,
No,
Branham says,
all right, we can do this one more time, but is there anything relative to him specifically, a document from ICE that says you're permanently excluded because of this conviction, Mr. DELANA?
there is not, but Granum does not require that. Granum, you can cite a policy or you can cite the statutes in the case law, and the point is that he can't continue.
He's just trying to get an answer to the question. All right, I'm all set.
That's on Granum, though, and the Tarrantee case.
Your time is up.
Thank you. Appreciate it.
Mr. Hanson.
Thank you, Your Honor. If it pleases the Court, Arne Hansen for the Commonwealth. With respect to the first issue, the judge did not abuse her discretion in not having an evidentiary hearing. It's well settled that a judge can rule on a motion based on the affidavits alone. An evidentiary hearing is warranted if there's a dispute of fact, and what we have here is a statement that is attributed to Attorney Glynn that is not contradicted in any part of the record that states that he doesn't remember the defendant, he doesn't have a file, and his customary practice at the time would have been to advise him based on what is on the plea sheet. An evidentiary hearing would have accomplished nothing beyond having him go on the record and say the exact same thing, that he doesn't have a file, he doesn't remember the defendant, and this was his customary practice.
Under Padilla, do you agree that that is deficient?
Correct. I think the case law is very clear that a defense attorney cannot just read the back of the form. They need to explain the rights further than that. So there's no argument there. So certainly the first prong of the ineffective assistant counsel has been met. And the judge credited all of this in her written findings. But that leads me to the second prong, which is the defendant must show prejudice. And in the way that he must show prejudice is that it must have been rational for him to reject the plea bargain at the time. And he can do that in 3 separate ways: by demonstrating that he had a substantial ground of defense, that a different plea bargain could have been obtained, or that he had special circumstances that would have warranted additional consideration. Now, with respect to the substantial ground of defense, this case was very strong. The defendant didn't cite any of the facts of the case in his brief. The police report was in the docket. It was a strong case for the Commonwealth. And the defendant doesn't claim that he had any substantial ground of defense. With respect to a different plea bargain, the defendant suggests that maybe Attorney Glynn could have found could have gotten pretrial probation or not a guilty plea or simply have amended the charges. That is completely absurd in these circumstances. The defendant was an adult male who assaulted a 14-year-old girl twice on the same day. He restrained her, and on the second time, he took his penis out of his pants while restraining the victim, used the victim's hand to rub his penis. To suggest that somebody like this wasn't going to be found guilty of a crime, it doesn't make any sense. So certainly, and the Commonwealth filed a motion to expand the record. There was a note in our file that reflected the sentences that were sought at the time of plea. So the Commonwealth at the time of plea was looking for 2.5 years, a year to be served, the balance suspended. The defendant was looking for the 4 months in the House of Correction, 100 days to be served. And the defendant got his wish. So it's clear at the time that no one was going to entertain anything below a guilty plea anyway. And the real issue at the time of the plea was how much time was this individual going to spend in jail, not whether or not he was going to go to jail. Now, with respect to special circumstances, these are the special circumstances that the defendant purports he had. He said that he moved here when he was 18. That is not a special circumstance at all, given the case law, and that he also had employment at a restaurant as a busboy. Now, given his interview to the police at the time, in October of 2001, he was in the country for about 7 months. In his affidavit, he said he came here in 2000 but failed to identify. So given the benefit of the doubt, the defendant had probably been here less than 2 years, certainly less than 2 years at the time of plea, potentially only 1 year. So there was no substantial connections to the United States at this point. He also didn't aver that he had family here. The employment part, that's not a special circumstance that I've seen. Some cases mention employment, but that's in relation to other things. I think the Lee case mentions that the person had 2 significant businesses, but that individual had been in the country for, I think, like 30 years, had 2 dependent children at the time of the plea. So those, I think the court weighed on those rather than just the fact that he was employed. I discussed at length what constitutes special circumstances in my brief. I don't know if the court wants me to go through that again, but certainly I think this case is probably most analogous to Rodriguez, where Rodriguez moved here when he was 17 years old and had family here. The court deemed that that was not a special circumstance. The defendant here moved here when he was older, was here for a year, and doesn't appear to have any ties to the United States other than being a busboy at a restaurant, which he was presumably fired from immediately after because he sexually assaulted a minor at that location. So there are no special circumstances here. The defendant cannot show that it would have been rational for him to reject the plea at that time. Additionally, the documents that the defendant filed in support of his motion demonstrate that the immigration proceedings had been started prior to this plea, referring to page 30. So this is not an argument I made in my brief, but I'm raising it now. Referring to page 30 of his record appendix, it states that on 11/16, he's being held at the Plymouth House of Correction, and the immigration proceedings had already started. So he was going to get deported irrespective of what happened with his case because he was here illegally. So for him, he has 2 options. He can take the matter to trial, which he'd sit in jail longer pending the trial being resolved. If he's convicted, he's going to jail for 2.5 years. The alternative that he had was plead out his case immediately, get 4 months, 100 days deemed served. Presumably, at most, he was doing another 20 days in the House of Correction, and then he was detained by INS anyway, and he was getting deported. So his choices were get deported now and be a free person in Brazil, or sit in jail for another year or 2 years or 2.5 years in the United States, and then get deported to Brazil. Under those circumstances, it's not rational for someone to be like, let me spend another 2 years in jail before going back to Brazil anyway.
What if he faced permanent exclusion?
I'm not sure I understand the question.
If would it have behooved him to go to trial if he was properly advised, knowing that this conviction would permanently exclude him?
So that's where the special circumstances argument comes back in. So in order to evaluate whether that's meaningful or not, the courts look to what substantial ties does this person have to the United States? What would it mean for him to be deported? Where he had been here for maybe a year, maybe 2 years, and didn't have any substantial connections, dependents, or anything of that nature, I don't know if that would have really weighed on him where he was brand new to the country and he had spent the vast majority of his life in Brazil. Does that address the court's question?
I guess what we talked about in Casimir and Granum was that you couldn't rely on a hypothetical circumstance. And Mr. Pomelo tells us that it's not hypothetical at all, that he faces permanent exclusion. He can't come back in because he's been convicted of a qualifying felony.
So that is based on the statements of defense counsel. There's nothing in the record that suggests that.
No, it took me a while, but I got there. But he says it's in Granum, says he doesn't have to show.
So, if I may refer to my notes, Your Honor, but I believe that Granum actually says the exact opposite, that you cannot just rely, to assert that claim, you have to do something and establish, and using evidence establish that that is actually the case, and you cannot just rely on the affidavit of counsel in that event, and that's why the Graham court didn't find that the defendant had met his burden. Now, that's a whole separate analysis. So with respect to the second analysis, the 278, Section 29 analysis, the docket is very clear that the defendant, I'm referring to page 108 of the defendant's record appendix, for both charges, the defendant pled guilty or admitted to sufficient facts after a colloquy and 278, Section 29D warning was given. So the purpose of that is to show that the plea was done knowing and voluntarily with knowledge of the consequences and that the alien warnings were given. Those were given, and then the plea was accepted. I think the docket is very clear and the case law is very clear that the Commonwealth can meet its burden by just showing that on the docket. Now, there's a couple of cases that I referenced, Diaz being one of them. That box, which is checked in our case, was unchecked in that case, and in that case, the Commonwealth was unable to meet its burden, but that's not our situation here. It's clearly marked off for both counts. Does the court have any additional questions?
Seeing none, thank you.
Thank you.
Thank you, Paul. Our next case is 23P 531 Commonwealth versus DEJESUS.
Good morning. Charlie Yellen for the defendant, Louis DeJesus. Your Honors, this case boils down to something very basic. For 6 years, the defendant wanted to testify, but something had to happen in this incident outside the courtroom to make him turn on a dime and to not testify, and it was an abuse of discretion for the judge not to explore this incident, especially where doing so at the time would have been so easy. Now it's much harder. We have a jury conviction, but we have considerable facts that are inconvenient, but we just can't ignore. And I think the most significant of them is that even though the impact of Tariq's actions and demeanors, Tariq is the brother who's involved in this incident, the impact of what he did may have dissuaded, may have caused the defendant not to testify, but we know precious little about those actions and demeanors.
Counsel, you said that in your brief, that we don't know, but it seems like we do know. We know a lot based on what seems to be facts that aren't in dispute. We have two statements about what Tariq said. We have statements about what the other, I think it's Tariq's brother, said. We have the impact that it showed on your client. Why do you need a hearing for any of that if the facts are undisputed?
Well, we have the two potential statements. okay? Let's take Tariq's statement, which is basically, we're not going to sit here and say, we used your laptop when you know damn well we didn't. Well, we both know, Your Honor, that's a line that can be delivered in a matter-of-fact tone or in a blood-curdling tone, as in the Robinson case. We know, as I think you may have mentioned, that the defendant is being approached by Tariq while he's saying it. Tariq's voice is growing louder. The defendant was in somewhat of a defensive posture. He said, I don't want to argue with you. And he had to be rescued. There's something there that needs to be looked at. How frightening was this? And the court officer is not, he's not a random person off the street here. He's a court officer. We're going to rely on what he says about that incident. And
so the incident, as we were calling it, is him saying, I hope you get the max, and he calls him some horrible names, but there's no overt threat.
Well, there's not an overt threat in a number of cases. For example, I mentioned Robinson in a show cause hearing where the defendant says, are you sure you want to go on with this? Well, I just delivered that in a very matter-of-fact tone, but the court said it was blood-curdling. There was no threat.
Okay, so, all right, so
but there's an implied...
Let's assume that Mr. DeJesus is afraid of Tariq and perhaps the other brothers. How does a mistrial remedy that?
Well, we're talking about protecting his right to testify. So what could have happened...
Yeah, okay, so let's say, so this is district or superior, right? It's superior?
District.
District, okay, so mistrial granted, and if there's a veneer there, the judge is gonna start impaneling for the...
I'm sorry, if what's there?
The veneer. If the jurors are there, he or she will just say, all right, we're gonna start again, mistrial. And then your guy's still afraid. So the mistrial doesn't accomplish anything.
Well, I think the option for the judge, we're talking about abuse of discretion here, the option for the judge said to counsel, what would make him more comfortable to testify?
And she added security?
She added security, but she asked what would make him more comfortable. And what counsel said was time. Time would make him more comfortable. This trial ended on a Friday early afternoon. Why not hold this to Monday, give him a little bit more time, the defendant more time to find his footing, counsel with lawyers. Now he comes back Monday morning, Your Honor.
Isn't it also within the range of reasonable alternatives for the judge to go, no, we're gonna try this case now. I've given you extra security.
I think extra security could be a boomerang. It could have caused him to be more stressful. And I think the answer to your question is no, because the only reasonable alternative, I think, was to find out what happened. If he's really frightened, if Tariq really scared him so much that he was paralyzed with fear, then we've got to do something about that.
The abuse, you say, is the judge's inability to gauge the tone of what these people said, even though everyone agrees what they said, the content of what they said.
Well,
it's just the tone. Without knowing the tone, it was an abuse of discretion for her to do this without an evidentiary hearing.
Yes.
Okay.
Tone, actions, demeanor, all of that.
But
Counsel,
you realize that even accepting that your client was, say, deathly afraid of this individual. Okay, so not a question. We accept that. And that it was an abuse of discretion for the judge to deny a motion for a mistrial to give your client more time to feel comfortable to testify. Start all over from the beginning, the whole new jury, in the hopes that he'll feel comfortable. That's an abuse of discretion. Because the way I read it is, Even if he's very concerned about his safety, a mistrial doesn't solve that problem. It's
You're
still going
assuming-
to be there.
You're assuming they've already had the hearing with the court officer?
Well, let's say that we can accept the fact,
That he's-
not even disputed, he is afraid, like many defendants may be, when they testify and say, someone else did it. Not an uncommon thing, I would think, to be concerned for your safety when you're pointing the finger at somebody else. So you're asking us, in those circumstances where a defendant feels concerned and chooses not to testify, that the remedy is a mistrial to give a defendant a chance to feel more comfortable in testifying.
Your Honor,
Is that your argument?
well, I think you're describing it in an extreme way, but yes, that is my argument, because I would add to that we're talking about protecting the right to testify, it's essential, and any disturbance or threat to a witness, this is the defendant, on the brink of testimony, on the brink of him testifying, any disturbance or threat can be viewed as interfering with the right to testify. Now, we can't ignore that. And the consequence of that in this case would be, I think the judge had the alternative of holding this to Monday, making the defendant more comfortable, and then revisiting the issue of a mistrial. But if his right is interfered with, we've got to do something.
Counsel, that's the connection I'm having trouble making. Why is giving a little more time, a day, a weekend, going to potentially alleviate the situation? Trial counsel specifically says the day before when this happened, I had to drive him home because he was so scared. If he's scared to go home, how is that going to get better over the weekend? How is it going to calm him down?
It might not have. It might not have calmed him down, but it would have been a reasonable alternative, the most reasonable alternative for the judge at that point, rather than doing nothing. You're saying they were ringing the courtroom.
The judge didn't do nothing. As Justice Meade pointed out.
Yeah, I was just commenting.
There was more security.
Yeah.
And I guess other than Tariq going to jail because of what could be deemed a threat or intimidation of witness, of which your client and counsel has no control over, nothing is going to alleviate this concern.
If I'm the judge in this case, Your Honor, I will have just witnessed this united band of brothers testifying against the defendant. The only person who could testify in his favor, the only one who, the best person to testify, is the defendant. If I know, I'm the judge, if I know that, and I know that the defendant wants to testify, I want to do whatever I can to make that person comfortable.
And that's why the judge specifically asks defense counsel, what can we do? And can you tell me where in the record, other than saying a mistrial, he says time?
Yes, he did say time. I can tell you that. It's there. I cannot find it at this moment. I'm sorry.
Okay.
I'll eat up all my time, which I can do if you want, but it's...
I guess I'm also, how do you compare this case or distinguish it from Texera at 76 Mass Appeals Court 101?
Well, I rely on Texera, and I think the difference, my sister pointed out, I think that, it was a state actor who was involved there, and there's higher scrutiny, there's more scrutiny, I understand that, but, the question is, was my guy intimidated or not? You're going to look closer, you're going to be more careful with a state actor, I get that, but and otherwise, they needed a hearing. It's a case I rely on, along with others.
Because there were facts in dispute in Texera. There was a question as to what the statements were. all three of us, I think, so far have basically said, we'll concede what Tariq's statements were. We'll concede that your client was really scared by them. We're trying to figure out, or at least I'm trying to figure out, why is a mistrial going to help the situation? Because that's what your brief talks about, an abuse of discretion in not granting a mistrial.
Right.
How does a mistrial help?
Well, a new trial, the counsel asked for more time. In his case, it was going to be he asked for a mistrial, and a new trial would have allowed more time and more opportunity for the defendant to become more comfortable. I mean, the fact is, we don't know the impact on the jury if the defendant testified. So the judge needed to do everything possible to make him comfortable. I think ringing the courtroom with police was not sufficient, and that she needed to do more. And if there are no further questions, I'll rest.
Seeing none, thank you. Ms. Lee.
Good morning. Excuse me. May it please the court, Mary Lee, Assistant District Attorney from the Bristol District for the Commonwealth. If I could jump back to a question that was asked before when the judge was asking, what can we do to make your client more comfortable? At transcript 4, page 18, I quoted in my brief at page 10, it's a trial counsel said, I don't think there's anything you can do I put do in brackets, you can do to make my client feel safe after yesterday. And so I took that to mean his answer was, there's nothing you can do at this trial to make him more safe, and he asked for a mistrial, and I think that's, so implicitly, my brother's correct, he's asking for more time because he's asking for a mistrial, but I don't recall a quote where he said he needs time. The defendant is claiming, he does claim structural error at some point because of the right to testify, but this is an abuse of discretion standard. He's claiming the judge should have ordered a mistrial, and short of that, she should have held an evidentiary hearing where she called the court officer who witnessed Tariq's confrontation with the defendant outside the courthouse to testify to see if a mistrial was required. And so for a remedy, he's either asking for a new trial or for an evidentiary hearing to determine that. There really wasn't any dispute regarding the proffer in court, but when Tariq was questioned about it, and he was questioned, he admitted that he saw the defendant outside the courthouse. He admitted, he was asked if he had animosity, and he said that he did not have animosity, but he called the defendant perverted and disrespectful. He said he saw the defendant outside. He had words with the defendant. He was specifically asked, did you tell him I hope you get the max, go to jail, and used coarse words for essentially saying he hoped he got raped in jail. He said, that's not what I said. What did you say? Tariq's answer was, you're really going to sit here and say somebody else use your laptop when you know damn well, excuse my language, damn well no one ever used your laptop. And so that's at transcript 3, 2008 to 2010. So the jury heard that there was a confrontation outside. The jury heard, I think everyone could take from that Tariq was biased. The jury also heard that he was, saying he didn't have animosity, so he was being cagey about how he felt about the defendant. He was asked, do you love the defendant? And he's like, no. So the jury knew all this about Tariq. All this was fleshed out. And so then the question is, if you called Court Officer Paiva to testify to impeach Tariq, what would he been able to testify to at trial? Because that was one of the things the lawyer wanted Court Officer Paiva to have testified at trial. And initially the judge said yes, but then she listened to the FDR and said no, that they couldn't call him to testify. And while he could have said, I hope you get the max, I hope you go to jail, I hope that terrible thing happens to you in jail, that doesn't add much to it. I think we can infer that the judge listened to the FTR and felt that this was sufficiently aired, and we didn't need that information from Court Officer Paiva to go to the jury.
Counsel, maybe I misunderstood the defendant's brief. I know during trial defense counsel said we should call him as a witness at trial. But I think what appellate counsel is saying, there should have been a hearing to determine how threatening that conversation was to decide whether it really impacted the defendant testifying or not. So do you agree that there is a dispute about the facts as to what Tariq said?
So the dispute only came from Tariq himself during his cross-examination, but the Commonwealth did not dispute those facts. I think the proffer was essentially the judge was satisfied that's what the court officer could have testified to. So then it comes to, well, what should we do now? The defendant's saying he's afraid to testify based on this. Nobody was saying that, even Tariq was saying, he was telling him not to testify. He was calling his defense preposterous, but he wasn't saying, don't testify. And so without that explicit threat, I think the judge properly exercised her discretion. She got more security. She made sure that the defendant knew he should get somebody to go with him, and counsel said he would go with him when going outside of the courthouse. Maybe you want to stick around inside the courthouse where we have more security. When Suleiman testified, that's Tariq's brother, she really laid down the law. He had an outburst. She sent the jury out. She told him, you keep doing that, you're going to end up in jail yourself. He apologized.
May I ask you something about something the judge did say that I have an issue with? The judge made a comment that I can't exclude these people from the courtroom.
Yes.
That's not accurate, is it?
So she did make that statement, that's correct. And so under Fernandez, citing Waller, the judge has to make a finding that closure of the courtroom can only be done for substantial reason. If the judge believed in these circumstances that having additional security and giving warnings to Suleiman and Tariq is sufficient, then she doesn't meet the Waller standard. So,
okay, and I want to talk to you about that. Sufficient to what? Under those cases, it's security for the courtroom itself. In this circumstance, the defense counsel, trial counsel, is raising concerns about the defendant testifying in his state of mind. In that type of situation, does a judge have to make a finding that if I excluded these witnesses, the defendant would be able to testify? Would that have been an appropriate finding to make?
She could have gone down that road of saying, I think if the judge made those findings that if I get everybody out of the courtroom and the defendant can then testify, that will be sufficient. But I think in these circumstances, she was looking at the proffer, looking at what was said, which was not a don't testify, and saying that doesn't meet the standard for closure of a courtroom, because she made this, her only statement on that is, you know, I can't close the courtroom.
Doesn't sound like there was a big balancing test there.
Well, the balancing favors open courtroom under all the courtroom closure cases. It's a very heavy burden under Waller versus Georgia, because that right to a public courtroom does not just belong to the defendant. If he waives it, it doesn't mean the case is reversible, but the right to an open courtroom belongs to everyone. And so the Waller versus Georgia standard is a very strict standard, as we saw in the courtroom closure cases that ended up resulting in Weaver before the U.S. Supreme Court. So the defendant can waive it, but he can't waive it for the entire public. And so I think that's what she was saying. That's a heavy standard, and she didn't see that the facts here met that when she said, I can't close the courtroom.
That's the entire public. What about specific people who, by the way, are witnesses? So
Commonwealth,
doesn't
yes.
the potential sequestration issue also come into play here? I know they've testified already, but they could be rebuttal witnesses or something,
So under Commonwealth versus Cohen, which is a Supreme Judicial Court case, even the exclusion of one person, because it was only a partial closure in Cohen, even the exclusion of one person requires that balancing standard under Waller versus Georgia.
We exclude witnesses all the time, potential witnesses.
Oh, for if there's a sequestration
So why
order.
isn't that in play here? Tariq's a witness. He's testified, so I guess an argument could be made the sequestration doesn't apply to them, which, by the way, is pretty unusual. Usually the sequestration order applies throughout the trial unless there's an exception made. So why couldn't she have excluded him as a witness?
My take on that question, as I saw it, was that the defense was asking to close the courtroom and not to exclude the particular witnesses. I do note the record shows that Suleiman left after his testimony. Tariq, according to the proffers, wanted to hang around and see the whole thing. So the judge would have to make that determination under Waller that nothing short of keeping Tariq out would be sufficient, and that she would have to exclude him from the courtroom. So we don't have a full record on that. What the defendant is suggesting here is that he was entitled to a mistrial. And so I would suggest the judge is correct that he shouldn't get a mistrial on this because of Commonwealth versus Weichel. I'll note Weichel got reversed later on other grounds, but it's still good law on the stance that it is. Weichel was involved with the Whitey Bulger gang, very dangerous, murderous gang in South Boston, and he didn't want to present his defense theory that someone else really committed the crime. And he was getting threatened by this very dangerous gang against himself and his family. And the SJC wrote in Weichel that a hard choice is not the same as no choice, and just because he made the wrong choice at his trial doesn't mean he gets a new trial for it. Here, we do not have a threat telling him not to testify. We do not have a threat against his family. We don't have an explicit threat at all. So he's not making as good a case as Weichel. He chose not to testify himself, but he did present his mother as a testifying witness to say other people had access to that laptop. So I would suggest that he doesn't stand in as good a place as Weichel, and therefore he cannot show an abuse of discretion on this case, claiming that he should get a new trial because he was afraid to testify. Additionally, he's not showing any prejudice here. We didn't get a motion for a new trial saying what he would have testified to. I rely on Commonwealth versus Brito for that. His statement to the police that he didn't do this and that other people had access to his laptop to commit this crime of child pornography was offered at trial along with his mother's testimony. So he can't show any prejudice prong there without having that motion for new trial with an affidavit of what he would have testified to, that it would have been somehow different. And so I would suggest that he hasn't made a proper showing. I think the judge, she looked at this case and she was saying, what are our options here? And she came up with options that are short of closing the courtroom. And those options that she permitted are that the witnesses could be impeached with their own conduct. She suggests the defendant stay inside of the courthouse or be accompanied when he go outside for his own personal safety. She arranged for more security within the courthouse. She asked the counsel for steps that would make the defendant more comfortable, and I point to that quote that I started with. She told the defense counsel if he thinks this is intimidation, he can go take out charges. He declined. She offered to inquire to the jurors about whether they'd heard about the incident. Defense counsel declined. She reviewed the FTR recordings of the previous day and determined from the proffer that Officer Paiva did not need to be called. I'd like to make a note about something. I read from the transcript at transcript 423 to 27. It appeared to me that the judge had some report from Officer Paiva. And I'm sorry to go outside the record, but in candor to the court, I spoke to one of the trial attorneys, and he said he never saw a report and he wasn't aware of a report. So perhaps I was reading the transcript wrong when I saw that. That's at transcript 423 to 27. But she definitely heard the proffers and was actually reciting the things that were in the proffer. So I don't know if I mistakenly read the transcript, and I apologize if that's incorrect in my brief. And she reprimanded Suleiman for his outbursts in front of the jury at one point, and then sent the jury out, and she struck his inappropriate comments. There were 3 outbursts by Suleiman, so she was very strict in hearing on those things. So she took a lot of steps. What she denied was the mistrial, because the defendant was claiming he was afraid to testify. He loses under Weichel on that. And to call the court officer as a witness to impeach Tariq, she may have found, after listening to the FTR, that this was sufficiently aired, and she didn't need to do that. And then it was to keep all the Mahmoud brothers out of the courtroom, which is the Waller issue. The defense counsel kept saying things like, these Mahmoud brothers, they all stick together. And she's like, No, we look at each person individually. You know, Tariq was treated, he was able to be cross-examined on what he did. Suleiman was reprimanded for what he did. But Ishmael, who is the person who got charged with the gun offenses, he just testified and then went about his business. Ishmael, who actually was hurt the worst among the Mahmoud brothers because he was prosecuted for his illegal guns in the house that were found during the search warrant for the pornography, he just testified. So the judge was doing her balancing here. She was being thoughtful and careful in this case, and everybody was surprised by this incident. And this is not a case like Texera, where you have a police officer saying you better not testify because that person's my family member. This isn't a case like Manning, where someone's trying to interfere, there are federal agents trying to interfere with someone. This is a case where someone who's not part of the court system, he's just a witness, is having a confrontation with no explicit threats, and the government is actually stepping in to make sure the defendant is getting all his rights. Officer Paiva went outside and brought the defendant back in and made him safe. The judge brought in more security and made him safe. And the defendant felt safe enough to call his own mother. And so I would suggest that the record shows that the judge made the correct choices, and I would ask this court to affirm the defendant's convictions.
Thank you. Thank you both. Do you want to do one more? Do you want to do one more? Sure. The next case is 23P1161, Four Seasons Motor Group versus Select Board of the Town of Swampscott. Mr. Patrice.
Good morning. May it please the court. This case involves my client, the appellant in this matter, Four Seasons, who had run a used car business in the town of Swampscott since approximately 2010. And the case involves an alleged violation of a condition of that particular license, which, if I can quote, it's brief.
We're aware of the condition, and I have a question. I don't know whether it's a condition or how the lot was actually being utilized. So a customer can go onto the lot, look at the cars, and if he sees a car in the back that has the little yellow sticker that says, "Do not sell," he can ask a salesperson, "Hey, I want that car back there. That's not for sale, but if you come back tomorrow, it might be for sale." And then they just switch it up. That's okay?
I'm not sure that was actually what the evidence showed.
I understand.
Your Honor.
I'm trying to figure out, because the evidence is a little unclear as to cars that are online, cars that aren't for sale. I'm asking you, would that, under your client's theory, would that be permissible under the condition with the town?
Would it be permissible under the condition?
Yeah.
Under the condition, the way we read it, absolutely. Because the condition itself is so vague and so ambiguous that there's no limitation on the amount of cars on the lot, the number of cars, whether the internet can be used. All it simply says, 6 cars to be sold. Doesn't even talk about the premises. So I think that would be permissible, to be perfectly frank. And that goes to the heart of the issue in this case. And what's amazing to me, Your Honor, on that particular issue is we raised it before the Board of Selectmen. It was discussed between the Board of Selectmen as to what it actually meant. Town Council actually gave advice on how to modify that provision because it was so vague. But that particular issue was not contained, even though it was raised at Superior Court, was not contained or referenced in the judge's decision. And that's, to me, goes to the heart of this entire case.
Well, he said you didn't raise it below, the legality of the section, right?
He said the authority was the word the Superior Court judge used. And I find that issue sort of intertwined between the authority to impose a vague condition as well as the authority to actually impose that type of condition on the license under the statute.
Where in the record was it raised before the board?
It was raised, I was actually asked directly about that. the ambiguity issue and the authority issue.
I thought it was in a letter, right?
That was in a letter, was in my proposed findings of facts.
I couldn't find it in the letter.
The issue of ambiguity was
Oh,
raised.
the legality issue of they don't even have the authority to do this. That's the issue.
That's,
the judge said
that's correct, Judge, but
that it wasn't raised below.
specifically, the legal authority to impose a condition was not raised in the letter. It was raised during the hearing, and that was at page 161 and 163, where the chairman actually brought it up, and I responded to it on lines 16 through 22. So it was raised below, and actually, surprisingly enough, if you look at the hearing transcript, the judge recognized that I raised it below on the record during the hearing, and that's at lines 7 and 8 at page 264, and lines 19 through 23 on at page 278.
The town says, if I understand correctly, that the limitation in that section, that statute, applies to Title III licenses, not Title II.
I understand that that's their position, but as I read the Rainier case that talks about an application for a Class II license, it refers to 140 Section 59, and our position, and the position of, in that case, was that there has to be town regulation or a policy in place before they can.
Does the section refer to Class III or Class II licenses?
Section 59 does refer to Class III licenses.
And Four Seasons was a Class II license?
Class II, that's correct, but I think the principle with.
Even though it specifies what class, that it applies to something that's not in the statute?
Well, that's what the Rainier case held, Judge. It was specific Class II license, and our position is there's a little difference in the facts because it was actually an application for a license and not a condition on a license in Rainier, but I would suggest that it's the same thing because a condition emanates and is based on the actual license itself.
So let me ask you this. You said it's vague, but does Four Seasons understood that the town had put a limit on their ability to sell cars?
Well, that's the impression that they want to provide to the court, and they tried to.
No. I'm asking you.
Okay. Our position is that for 10 years, there was various conditions in place. There was never.
Let me ask again. Did Four Seasons and its owner understand that there was a limit on how many cars they could sell?
Yes.
Okay, so and the owner himself testified that if someone wanted to buy a car that was not for sale, he would just switch the signs and put a for sale sign on that car and put the other one be rendered not for sale because it no longer has a for sale sign. Is that correct?
Yes, Judge.
Okay, so how is that a limit?
Because of the actual conditions, 6 cars to be sold. The question is 6 cars to be sold when? Per day? Per hour? Per year?
Well, let me ask it differently. How is it a limit if you can pull the little switcheroo at any given time when someone wants a car that's not marked for sale?
Because, Judge, it depends on how you interpret that vague and ambiguous provision.
You've agreed that the Four Seasons understood there was a limit on their ability to sell cars, the number of cars they can sell. And yet, you say that they can just switch the tags around and sell any car on the lot, which sounds to me like no limit.
Well, Judge, I would have a question with what the actual condition said and what my client understood. 6 cars
limits, 6-car limit.
To be sold. It doesn't say anything about how many cars are even advertised on the premises. My view, quite frankly, there could be 40 cars with for sale signs on it.
Well, there were 58 cars on the lot.
But they didn't all have for sale signs.
Oh, you only had 6 until someone wants to buy one that's not marked, and then you just put a for sale sign on that one.
But that's my point, Judge.
That's my point, is that there's no limit here.
I understand. Well, that's the problem with the condition. It says 6.
Well, there is no condition.
6 cars.
Basically, the owner the owner of Four Seasons, even though he understood it was 6 cars to be sold, whether it's a day, a week, a month, I don't know, there is no limit, because he's asking the same question that I did.
I
which is
understand
They
that.
switched the sign, and Four Seasons owner then said, if we sold that car, we would then move another car into that slot to be sold. So there is no limit.
I agree with you. There shouldn't be a limit in terms of any interpretation of that condition. 6 cars to be sold is so vague and so ambiguous. I don't see an issue with
No.
it.
Six is a number that we all understand. It
Yes.
comes after 5 and before 7. That's not ambiguous at all. So the undercover detectives wanted to buy a car that was not marked for sale, and the salesman said, no problem, I'm just going to put a for sale sign on it. Bingo, you're in luck.
But that's not what the testimony was. And the condition says to be sold.
What did the detectives testify that I got wrong?
Well, bearing in mind that there were 2 police reports, and neither police report, which they all signed off on, said they were shown more than 6 cars for
Did they
sale.
make inquiry to purchase a car that was not marked for sale?
That was one of the Detective Gay.
They make inquiry to purchase a car that was not marked for sale?
Yes, that was the 7th car that she testified
And
to.
was that car offered for sale to them?
That was her testimony
So-
at the hearing.
So thank you, I
if
didn't misunderstand.
If I
Can I just-
understand
I'm
your
sorry.
argument, which seems to me maybe the only argument that I can glean from this is that you're not in violation of this 6-car limitation as long as you don't try to sell more than 6. So if you put 7 cars for sale, then you would agree with me that's a violation of the town's 6-car limitation, correct?
I'm sorry, Judge, in terms of clarification, you say as far as for sale signs or just cars available to be
Sale
sold?
signs. So if you walked onto the lot and there are 7 cars with for sale signs, you would agree with me that would be a violation of the 6-car limitation.
My opinion, Judge, I don't think it would be, my opinion, because it's 6 cars to be sold, not six cars for sale on the premises, 6 cars to be sold. So I personally think,
Well, there are 7 cars to be sold on the premises.
well,
That would be a violation of this restriction?
I don't believe it is actually, Judge, because
What would be a violation then?
That was my
What
question.
would be a violation of this restriction?
in terms of speculation, if he sold 8 cars that day, if 8 cars were sold, that would be, to me, a clear violation of it. But to advertise 20 cars or 40 cars, the condition is cars to be sold. And that's the problem with this case. It's so ambiguous and vague. Respectfully, I'm speculating here on the record now. It shouldn't have to do that. That condition should be clear and concise.
So your argument then is that the condition means that per day, only 6 cars can be sold. He could advertise for all 58 cars, but as long as he only sells 6 that day, he's in compliance.
Judge, my comment was speculation because I don't know what the condition actually means. It could be
Your client had this stipulation in place for however many years. He had to have an understanding as to what it meant. So what was it that he thought it meant?
He thought it meant that he could sell 6 cars at a time. I think.
At a time?
At a time. 6 cars at a time. And that was in place for years, and there was never a problem if they...
I'm trying to understand that. So what that means, based on what you just told me, is if 6 customers come onto the lot and they say, we want to buy these 6 cars, 1, 2, 3, 4, 5, 6, he can sell them, right?
Correct.
Now, your client testified, I believe, or stated, that once that happened, they could bring new cars into those spaces.
6 new cars.
And so if 6 new people come on and say, all right, now we want these 6 cars, that was okay.
Absolutely.
So there's no limitation. I mean,
I think again, and I've said it a few times, and I apologize, but the condition is so vague I don't think there could be a limit based on what it actually says.
What was the purpose of the town's limitation?
That's the really unbelievable thing, Judge, because the purpose of it, and you can see on the actual decision, they say allotted cars on the premises for sale. That should have been in part of the condition, how many cars should have been on the premises.
You're worried about congestion.
Absolutely.
And the property being overcrowded with cars.
Absolutely. And
so how does that make the number 6 vague? It wants to limit the amount of cars that you can sell in that lot. It doesn't want 58 cars.
And the matter of fact, Judge, there were 58 cars or 50 cars on that lot for these people for years, and there was never an issue.
They were just slow to enforce their limitation.
Well, I think the other issue that wasn't addressed by the Superior Court judge was bias in this case, because if you look at the facts, what the real issue was, to get right down to it, Your Honor, is Attorney LeClaire sent a letter to the town of Swampscott complaining about the fact that once the license was renewed annually, the town didn't bother to issue it for 2 or 3 months. And my client was precluded from carrying on his usual business for that period of time.
That smacks of retaliation, not necessarily bias.
Well, it was biased during the hearing in terms of the testimony from the witnesses. Attorney Gay, who testified for Marblehead that she was actually shown 7 cars, the police report that she filed said that she was showed 5 cars, or not more than 5 cars. So, and that goes to the issue of whether there's enough evidence of record to even justify the violation of the condition we've been talking about. But the point is, as soon as that LeClaire letter was received by the town, within 2 weeks, there was an investigation by the town of Swampscott. There was a sting operation, the first of its kind, between Marblehead and Swampscott.
It was interesting, but you're out of time.
Thank you.
The town's going to tell us why they hired Marblehead.
Thank you, Judge.
Are all the undercover detectives well-known in Swampscott?
Good morning, and may it please the court. Keelan Bogart Ciccarello for the Select Board of the Town of Swampscott. The Superior Court's ruling in favor of the Select Board was proper and should be affirmed.
Can I ask you a procedural question? You talk about certiorari in the opening section of your brief, but this is a 30A, right? I know the standards are very similar, but...
Correct, yes. So under 30A, Section 14, you would need to find either, it wasn't supported...
But it's not certiorari.
I'm sorry?
It's not certiorari.
It's, yes, under Section 30A, Section 14, or Chapter 30A.
That's administrative review. Your brief talks about certiorari.
Oh, I apologize.
249.5, yeah. Because there is a remedy here, and it's to go to the Superior Court
right.
under 30A. Okay,
right,
just want to
correct,
make sure. Okay,
yes. So in this case, unless you can find that the decision wasn't supported by substantial evidence, if it was arbitrary or capricious or otherwise not based in an error of law, it should be affirmed. And I think the record is clear that there is substantial evidence on which the board could make a reasonable decision in this case. As mentioned, we had the testimony of the owner. We have testimony of 2 undercover police officers who testified that they were shown cars that were marked as not for sale.
Why did you use Marblehead rather than Swampscott?
So I know that the chief of police for Swampscott initially did the check to make sure that the operation was following the condition, and I'm not sure why they ultimately selected Marblehead police officers to do the sting operation. But ultimately, what they did find was that there were cars marked for sale, as mentioned, 6 cars marked for sale, but then there were other cars marked not for sale that were shown and were talked about. And according to the owner's own testimony, the 6 cars in the front were the ones that were marked for sale, and those were the ones that would get rotated out. But when the 2 Marblehead police officers went to check the space, they were actually shown cars in the front, in the back, in the garage. So they were shown not only the cars that were marked for sale, but they were shown cars that were...
Some, I should have asked Mr. Patrice, some had lemon law stickers on them. I know what the lemon law is, but
right.
What does the lemon law sticker say? This car is is a lemon, or just to inform people of their rights?
So my understanding of the lemon law sticker is that only needs to be applied to cars that are for sale. And what the police officers found was that most of the cars, if not all of the cars on the lot, had those lemon law stickers. So while they might have had signs that said not for sale or no sign about whether it was for sale or not, they all had those lemon law stickers, which might indicate that they were getting either prepped for sale or were available because they had those
But
stickers on
it's
them.
notification of what the lemon law protects the consumer.
Correct,
All right.
correct.
So the stipulation says, quote, "Sales are limited to 6 used cars to be sold." It
Correct.
doesn't say how many cars in the lot. It doesn't say how many are advertised. It says 6 to be sold. What evidence in the record is there that more than 6 cars were being sold per day?
Sure. So I think the testimony from the 2 undercover police officers is the most compelling to show that there were more than 6 cars available. So they're the 6 cars that are marked, clearly marked for sale. And then the car that they were specifically shown that was marked not for sale, they were given a price and they were allowed to look at the car, which that means that.
But it says sales are limited. I read that possibly to mean that there can be 100 cars advertised, but it's limited to selling, the actual selling of 6 cars.
Right.
Permissible the way that's written, right? So 100 cars are for sale, 6 people come onto the lot, they buy the first 6 cars. If they close the lot at that point, or they say to people coming in, sorry, no more cars for sale today, that's okay, isn't it?
I think that is walking a fine line with the condition. I think the condition is pretty clear that only 6 cars can be sold at a given time. And I think based on the operations of Four Seasons, they understood that that's what that limitation was, that 6 cars, otherwise they would have all those cars marked for sale, and they would only limit themselves to 6 sales in a day, or whatever the parameters would be.
You said it's pretty clear. I got news for you. It ain't pretty clear. It says sales are limited to 6 used cars to be sold. That, to me, I don't know the time frame is, you can only sell 6 cars.
Yeah, and I see your argument, I do. But I think in practice, it makes sense. And when you think about why the condition was in place, the whole purpose behind the condition and the intent was to keep an area that's already very congested from expanding and getting more congested. And so when you...
Can I just interrupt here?
Yes.
The language doesn't say sales are limited to 6 used cars, period. Then this argument of shut down as soon as 6 cars are sold and come again tomorrow, I guess would be okay. The language says sales are limited to 6 used cars to be sold. If you read that entire sentence together, it seems to me that it's not selling 6 cars, it's to be sold.
And I think it's both. I think it's having cars advertised for sale and selling 6 cars, right? So and that is how this seems to have been interpreted by Four Seasons as well, with the shuffling of cars, determining that one car is not sellable or isn't selling, to shuffle that out. That's, 6 cars to be sold is how it was interpreted, both by the select board and by how the operation was run.
Yeah, I think you'd agree that since the goal was to avoid congestion or overpopulation of cars, that the to be sold means that there should only be 6 that are available for sale.
So yes, but I understand that there's some kind of back office things that happen with selling of cars, and so if you have 6 up front, you might have a few extra as you're working through the process of selling cars. So to that extent, yes, I do think that it is limited to 6 available out front for sale.
And doing the switcheroo contravenes the
Right,
reason.
because ultimately then it's not based on whether the car is actually for sale, it's based on whether there's interest in the car. So as soon as you have interest in the car, that car gets rotated
or the car
forward.
physically being there.
Right,
That's
right.
not to be sold.
Right.
But they're happy to sell.
Exactly, right. So that interest then triggers that, whether it's for sale. And I think it's important to note as well that this, Four Seasons has had this license since 2010, and they have not appealed this condition. And it's been reissued each year until 2019 when this show cause hearing took place. So at this point, both the select board understood the meaning of the condition and Four Seasons did.
Mr. Patrice told on the validity of Section 59, I think, that he says this Rainier case, is that an SJC case?
No, so I believe that's an appeals court case, and actually, I think it's important to distinguish Rainier from what's happening here. So in Rainier, the town established a policy in which they created a 20 license cap for Class 2 licenses. But this cap wasn't strict, so they had kind of unfettered discretion to then grant or deny more licenses beyond 20, and they didn't have a standard for how they would either grant or deny those licenses. So the court kind of found two things, that kind of unfettered discretion was arbitrary and capricious, and then the cap itself is against the whole notion of Chapter 140, Section 59, in which it should be a case-by-case review for these things, and it shouldn't just be this cap, this arbitrary cap. So I think that's very different from what we have here, where the select board placed, sorry.
Mr. Patrice told us that Rainier extended the restriction on Class 3 licenses to Class 2 licenses.
I don't think that's what Rainier stands for. So it is true that under Section 59, Class 3 licenses do have this requirement to have a bylaw or an ordinance to grant that authority to the select board to place a condition. But that's not true for Class 2, and that's not what Rainier held. Rainier held that a cap, an arbitrary cap, is not within the scope of Chapter 140, Section 59. And so it's not relevant to our situation here.
What about bias?
Well, so I think the claim of bias is unfounded. One of the things that was mentioned is that, the issuance of the license was delayed for a couple of years. Each year it was delayed a little bit. But during testimony, I think it was the town administrator actually admitted that it wasn't just the Class 2 licenses that were delayed. This was a systemic problem in which, the liquor licenses were also delayed for that year. So it's not something that I think speaks to bias specifically to Four Seasons.
Does the prior license remain in effect until the next one comes?
It doesn't. So my understanding is that it expires, but that was also a question for the town administrator, who said that they don't actually, he used the liquor license as an example. He said they don't go after people who had a liquor license and it expired.
They don't close you down when you have an expired
Exactly,
license.
Yeah. So whether it wouldn't have been enforced in that manner is how I understand it. And if there are no further questions, we'd like to rest on our brief.
Seeing none, thank you.
Thank you
We're
very
going to take a
much.
short break.
All rise.
next case is 23P1116, Chad Oakes versus Shelly BILDEN-OAKES. Mr. Colangelo.
Colangelo, yes.
How close did I get?
Pretty close, pretty close. I'll accept it. Tristan Colangelo on behalf of the appellant Shelly BILDEN-OAKES. Your Honors, this appeal really presents just one issue. It's whether the trial court's ruling not to grant the wife's request for alimony should be vacated. The court reviews the alimony determinations under an abusive discretion standard, and there's a two-step process, but really the argument focuses on the second step, which is the supporting spouse's ability to pay and the dependent spouse's need for support. And here, we're arguing that the trial judge miscalculated both of those items, both that the husband had the ability to pay and what that ability was, as well as the wife's need. The husband's brief, they conceded that the trial court miscalculated the husband's net weekly income, which, from our perspective is fairly significant. It switches from having a negative net weekly income to a positive net weekly income, which leaves the second issue about his ability to pay, the inclusion, or I should say the exclusion of all his sources, mainly the retirement contributions to the TSP account. So as the court knows, in the SJC and Kavanaugh recognize that employer contributions to retirement should be included as a gross income calculation for purposes of alimony. And in my brief on page 21, I summarized those in a chart, as well as the record citations.
Right. So if we're to agree with you, and the trial judge indicated the wife had certainly spent more than was coming in, right? And that the husband, if we agree now with the concession, that the husband did have an ability to pay. It seems to me that then the counter-argument is, okay, so what? Even if the husband had some money to pay, the judge says, I can't find and make a ruling on alimony because there wasn't enough evidence presented that tells me what the needs are. In essence, living in a home in Braintree and having a house cleaner every few weeks isn't enough for me. So I wonder if you could address that issue as to where in the record is there evidence of need as far as marital station is concerned?
Evidence of their marital lifestyle?
Yes.
Yeah. So Your Honor correctly pointed out, I mean, the testimony, it was in the transcript, pages 13 to 15, where they say that they lived in a 4-bedroom home. There was a professional cleaner that came every few weeks. That's on page 18. And on what I think is really the significant facts that go above and beyond that, it's the transcript on page 20, where there's the testimony that, and I believe this was the husband, that they earned enough income to pay off all their bills on a monthly basis and still had $5,000 of disposable income left afterwards. And that's fairly significant and I think very specific as to what their lifestyle was. I mean, it includes where they lived, the kind of house they lived in, whether they were able to have someone come in and help out to clean the house, as well as what the disposable income would be after paying all the expenses. So I spend a fair portion of my brief going through what the lifestyle is of my client at this point, just to show that she went from a marital lifestyle in which they had $5,000 of disposable income to...
And I'm not trying to be funny about it, but I mean, I looked at the record a number of times, and the best I could get is Record Appendix 3 at 785, where the wife says, well, what was the difference in your lifestyle? Well, before, I lived in a house and I wasn't picking up dog feces. And if I were the trial court judge, I'm not sure I could make a mathematical kind of equation of, well, then we need to give you X amount of dollars. In my mind, and obviously I wasn't a probate court judge prior to coming to the appeals court, but it would seem to me to require proof of, this is what lifestyle. We went on cruises every year, and those cost about $10,000 a year. And we had 2 luxury vehicles, a BMW and a this, and they were both valued at X amount of dollars, but the kind of cursory, you know, I didn't live in an apartment and I wasn't cleaning up after dogs. Is that enough for a judge to make an alimony determination as to marital station?
So in isolation, you know, I mean, obviously that's pretty high level testimony on her part, but that's not the only testimony that there was. I mean, you do have to consider the husband's testimony as well as to what their income levels were and what they did. I know that her response there is fairly concise, to say the least, but I don't think that is the only thing that the court should look at in order to determine whether the record sufficiently allows a trial judge to determine what the lifestyle was.
So you have the fact that they lived in a home in Braintree, a 4-bedroom home, that the testimony that at the end of the month they had $5,000, that their bills were paid and $5,000, and you know, they had as excess, and they also had a professional house cleaner.
There's also sorry. Well, there's also the testimony about the retirement savings as well. So during the period of the marriage, they were both able to contribute to their retirement accounts, and the wife has testified that she's unable to do so post-divorce. The husband obviously is able to do that. He testified to it, as well as he has the employer contributions. So there is additional evidence concerning what the lifestyle was during the marriage. And I mean, I guess this is the type of case where we're not dealing with a $2 million income, right? I mean, there's no, I don't think the argument is that he makes so much money that he'll be able to fully satisfy both of their needs up to or beyond what it was during the marital lifestyle. But I mean, the case law is pretty clear, and I cite Calvin C. from the Mass Appeals Court, and the SJC said this in Kavanaugh, that there needs to be a fair balance of the sacrifice if there's not sufficient funds to cover the marital lifestyle for both parties. So
basically, once the mathematical computation is corrected, and for lack of a better analysis, the husband is on the plus side of the equation, your argument is that it needs to be reversed and remanded for consideration of alimony.
Yep.
Period.
Yeah, it should be. I mean, there are the other arguments that, the argument that there is sufficient evidence regarding their marital lifestyle. I think that needs to be, part of it. If there was no evidence at all presented as to the marital lifestyle, that would, I think, be problematic. Here, I think there is enough. Frankly, when I was reading the findings and conclusions from the court, the first determination was that the husband didn't have sufficient, he had no ability to pay because he didn't have sufficient income. And I really read that as sort of the primary reason for denying it. There was an alternative, and, Your Honor correctly points out that, she made the finding that it wasn't able to determine what the marital lifestyle was. But I think upon review, when you look at all the facts, it's clear that there's enough here to show not only does he have the ability to pay, but that there is a fairly comfortable marital lifestyle that was enjoyed that certainly she's not able to even come close to at this point.
What about the judge's finding regarding your client being underemployed? Do you find error with that?
Yeah, the attribution of income. The argument here is that so the wife testified in 2019, the first year that she was primarily a guardian and a Rogers monitor. Her income was about $69,000. The court determined that she was underemployed and attributed it to her income to $85,000. But the findings that support that really rest on this inference that the court made that of her 197 clients, about 30 or 36, she could bill Mass Health, $1,200 a year for those. There's just no evidence in the record at all to support that finding that, about 15% of her clients would be eligible for her to bill Mass Health for. So without any fact to support that inference, it's an abuse of discretion. And I cite two cases, Schechter and Friedman, that sort of stand for that idea that a finding is just clearly erroneous if there's no factual support to underlie it.
But educate me on this point. If the judge found that the wife in this instance needed support, and if you're suggesting that that the judgment be reversed and remanded because of the mathematical equation that the husband had an ability to pay, does it really matter whether she was underemployed or basically her bills exceeded what she was making even at the high range? So the judge admits, yep, she has a need, right? She doesn't make enough money to cover all of her bills. But husband doesn't make enough money to cover his bills. And so what you're suggesting is that that was wrong. He does have enough money at the end of the day. Do we need even to address whether or not she's underemployed? Because even at the higher level, her bills still far exceed.
Yeah, I mean, I think what I'd ask for is that upon remand that the judge take that into consideration and obviously be guided by the ruling of this court. If it is determined that that finding is not supported by any fact, then the trial court will have to either reevaluate the attribution of income or revisit that finding and perhaps lower it to whatever would be present day. I mean, if it's remanded, then they're going to have to resubmit financial statements. But obviously before while I was drafting the brief, my brother hadn't conceded the point about the husband's income, so really had to attack that finding from both sides. I know this is just a one-issue case. If there's any other questions, I'll take them. If not, I'll rest my brief.
Thank you very much.
Thank you, Your Honor.
Mr. Spencer.
Good morning, may it please the court. Sean Spencer for the appellee, Chad Oakes. The only issue that should determine the outcome of this appeal is whether Judge Burchill abused her discretion in finding there was insufficient evidence of the marital lifestyle. My client could be earning an NBA max contract and the wife could be entirely unemployed. It wouldn't make a difference because the first step in any alimony determination has to be what lifestyle did the parties live. That enables the next step, which is to say, what would it cost to continue the recipient spouse at the time of the divorce in that lifestyle? And only then do you say, are her available income and assets, do they meet that need or not? And if they don't, then she has need, and then you get on to ability to pay. We're all the way back at step one. This court's description of what needs to be the case, what evidence there needs to be in Cooper versus Cooper, I find instructive. There was a modification of alimony, and this court vacated it because there was just no connection between the alimony award, which was a percentage of the husband's huge Goldman Sachs income, and the marital lifestyle. And what the court said was, in the absence of specific findings grounded in evidence that the amount was consistent with that lifestyle, the award cannot stand.
But that was an error on the part of the judge in not attributing particular amounts, right, to then justify why 18%, I believe, in Cooper was the amount that was going to be modified on the alimony. So here it seems as if some of the evidence potentially, and tell me why it couldn't be considered. I mean, the husband provides his financial information. And you see, he's shopping at Crate and Barrel. He's not shopping at Walmart. He has a Crate and Barrel card. Why can't the judge take into consideration that he not only shops or has a Crate and Barrel credit card, but that it's paid off at the end of the month? Why can't the judge consider the fact that both at the time, right prior to the separation, both husband and wife were contributing to their retirement, which is testimony in the record, that at the sale of the home, there was significant equity that was built into the house. And that statement by the husband where basically on most months, except for a few spikes, they had about $5,000 of disposable income. Now, sure, it's not the drill down every year we would be on the French Riviera and that cost us $10,250. But as far as a picture of their lifestyle, what they enjoyed, what they were accustomed to, they lived in a 4-bedroom, 2-bathroom home with significant entry. Monthly, they were contributing to their retirement. They shopped at, or he shopped at least at Crate and Barrel and others, and at the end of the month, they had $5,000 left in a pot. Why isn't that enough for the judge to then make a fair determination of, if the concession that the mathematical error happened, for the judge then to make a determination on alimony?
It's because we have absolutely no idea what the conduct was, what they spent on the Crate and Barrel card. Did they buy a kitchen item once a year, or were they, racking up $500 a month in luxurious purchases? There's no way from this record to determine.
But do they have to spend it? I'm sorry to interrupt, but so in other words, if you're a husband and wife and at the end of the month, every month you have $5,000 and you say, this is going to be our nest egg for something else or whatever, does it actually have to be, no, we bought $5,000 worth of expensive fine china every month? In other words, that just to me is an indicator of where they're at, where their comfort zone is, where they could draw on in case their car died and they need to get a new car or whatever, kind of their lifestyle.
The dollar amounts that one could show in a case like this aren't necessary, but what they are, and what I think what trial counsel would ordinarily do, is use the dollar amounts that you spent, what show statements of banks and credit cards during the marriage to show what lifestyle you did live. Because absent that evidence of what the parties did, you can't tell. Did they live very frugally? Were they very thrifty? Were they spending lavishly? And there's no judgment in the alimony determination. But
So can I just, so if they were frugal, that means wife doesn't get anything? But if they were lavish, she gets it?
what both parties get, depending on who needs support,
Right.
is support up to the style of the life which they lived at the time of separation.
So
That-
if you weren't spending the money, but you were saving it, right? Because that's what the union decided, that we weren't going to buy the Beamer, we were going to buy the Kia. So to me, that doesn't necessarily, the result would be, well, they were good savers. Now, even though they had all this extra money that they agreed to, that husband doesn't have to pay alimony, because that's part of their lifestyle back there, was to have a good nest egg, right?
And so the SJC just addressed this, that if you demonstrate, and I apologize for bringing in a case that we haven't cited, but it didn't exist before we cited it, and I didn't see it as part of the argument. But if you can bring in evidence and demonstrate a pattern of savings during the marriage, that is part of the marital lifestyle.
What case is that?
That's Openshaw versus Openshaw, 2024. And so, I mean, that just, it makes the point that I think I've been making all along, which is you've got to demonstrate what the parties did during the marriage in order to enable the probate court judge to make the subsequent determinations. Without that first step, it's just guesswork. And it can't be, I mean, our alimony law is not a correction of income disparity. And really, the Cooper and the Young cases from the SJC make that point. The massive disparity in income doesn't mean that you carve out a percentage of it and give it to the recipient spouse.
So in this case, if the wife had submitted the credit card bills, the gas bills, the electric bills, and said every month these were all paid off and it equaled $10,000, and with all those paid off every month, we still had $5,000 left over, that would be sufficient?
Yes. Yes, Your Honor. because it would tell us what the parties did, what style of life they lived in. We can't just assume it.
We don't have to assume, do we? Because the husband's testimony was that the credit cards were paid off, right?
But I don't know what was paid off. I don't know whether it was just a small amount of weekly activity or whether it was $20,000 a month in luxurious spending and meals out and travel. And we can't know because the wife didn't meet her obligation below, and it's always hard coming in as appellate counsel to see what what justifies those decisions. But the decision was made, and the evidence wasn't submitted. And Judge Burchill, I'd suggest that if she had found a marital lifestyle and then attached a value to it today, I suspect I'd be here arguing that that is an abuse of discretion under Cooper, because there's just not evidence for it. I want to correct a mistake in my brief that I noticed in preparation for argument. In the last section, I say there's no evidence of the retirement contributions. I was focused on during the marriage. And of course, it's stipulated that post-divorce, the contributions were made. I just don't want that to sit uncorrected on this record. I don't think it changes anything about the outcome, but I want to be clear.
Do you also agree that the judge should have considered the contributions to retirement in determining whether the husband had an ability to pay?
That is part of income for alimony purposes, but I'd submit that you could have written a shorter set of findings. I mean, she went through at length on marital lifestyle, 10 paragraphs of her findings on just what's missing on marital lifestyle, and she could have ended there. So I don't think she could or needed to consider any aspect of the husband's income. Thank you, Your Honor.
Thank you. Thank you both. Our last case is 23P940, Department and Children of Families versus Father and Mother. Just a reminder, this case is impounded, so please don't use any names. Either use identifying titles or characteristics or mother and father, child.
Yes, Your Honor. Good afternoon. May it please the Court, Roberta Driscoll-Weiss here today on behalf of the appellant mother. I will be sharing my time with my brother who's here today on behalf of the appellant father. I'm here today to ask this Court to vacate the judgment terminating my client's parental rights and remand the matter back to the juvenile court because the trial court lacked the requisite evidence needed to find that mother exhibited the grievous shortcomings that placed the child's welfare very much at hazard and that she could not provide minimally acceptable care for the child. That is the standard in these cases. And I would submit to you that the trial judge terminated mother's rights essentially for one reason, and that was mother's substance use disorder. And I think in that case, we need to look at the adoption of Catherine. Adoption of Catherine is a decision by this court which very clearly says that the court must find some link, some connection between the substance abuse on behalf of a parent and the harm to the child. And I submit to you, Your Honors, that that evidence is lacking here. This child was removed from mother's care because mother had an open case relating to an older child, and this child was removed at birth. This child, despite the erroneous testimony of the social worker, was not a substance-exposed newborn. This child was born with only methadone in her system and was removed largely because of this earlier open case and because mother and father were suffering from housing instability at the time of the child's birth. Admittedly, mother did not distinguish herself early on in her relationship with DCF, particularly regarding the older child. She did not engage with DCF, and shortly after this child was born, mother executed an open adoption agreement with respect to the older child. But at that point in time, mother's conduct with DCF and her engagement in services changed dramatically, and the record is clear that at the time of trial, Mother had engaged in services. She was in full compliance with her service plan. The clinical program director from her drug treatment program came and testified as to her consistent engagement in services, her participation in urine screens, DBT, therapy, clinical services. She underwent a parenting evaluation. She obtained stable housing such that the state of Connecticut approved the interstate compact home study that DCF requested. So at the time of trial, Mother had remedied many of the issues that had raised concern for the department and for the court. Admittedly, Mother suffered a relapse shortly before trial. But if we look at adoption of Luke is an SJC case that says very clearly that a parent's rights cannot be terminated based on substance use alone despite relapse if that parent continues to engage in services. And I think there's no question here that Mother...
She engaged in services, but didn't the judge find that she failed to understand the effect her addiction has on her ability to care for the child?
I think any finding to that effect was not supported by the evidence, because Mother very clearly testified that when you're a drug user, when you have a substance abuse problem, your child is removed from your care, and that's harmful to a child. So I think that was in part a realization. DCF also acknowledged that Mother was able to discuss why her fentanyl use was a concern for the department. The social worker testified to that fact.
So it's okay to use fentanyl and it won't harm the child because she knows the child's going to be taken away every time she uses fentanyl?
I don't think that's my, at least I hope that's not my argument.
I hope so too.
What I'm saying is that had we to do this case again, if this case were remanded, what the trial judge should have done is taken an approach such as that's described in adoption of Carlos. Could the judge find that Mother was currently unfit to parent the child at the time of trial? Possibly. Was the evidence sufficient to terminate her parental rights? I suggest not, and I suggest what the trial judge should have done was continue the case for 6 months to determine whether or not Mother could consistently remain engaged in services and continue to parent, continue to do the things that would demonstrate to the court that she could parent this child. It also would have alleviated the judge's concerns, which I argue are unfounded on the record, that the separation between mother and father was simply a tactic. I think that's what the judge said. It was simply a tactic to regain custody of the child.
The judge, he also found that Mother didn't realize that being around father was a trigger for her own addiction.
And again, I think the judge speculated that was the Mother's position, but Mother's
he gave her drugs.
And Mother's testimony at trial and Father's testimony, which was unchallenged by any other evidence, was that they had separated. Father had obtained another place to live. Father, I think, this is not a case where there's a long litany of instances where one parent or another was untruthful. You know, we see cases...
Can I interrupt for a moment? Never mind. That's okay. Never mind. Thank you.
I think both parents were very forthcoming about their...
Okay. Now I got to go back. Forthcoming is not how I describe where are you living, and a refusal to even say where this new place of residence is until maybe after a phone call could be made to say whatever, and then to come back in and say, okay, now I'm going to say where I've been living away from Mother. I didn't take that as forthcoming. In many other areas of the transcript where I didn't see forthcoming testimony, in fact, the opposite. So I may quibble with that characterization.
I appreciate that, Your Honor. I would just simply point out that Father also took the stand and said, I was the one who brought the drugs into the home. I was the one who didn't listen when she asked me not to bring the drugs into the home. I was the one who encouraged her substance use. I recognize that my being there was a trigger for her, and that's why I've left. So
This was all at the 98th minute, right, of 100 minutes, and the judge recognized, but the mother still didn't recognize. In her relapse prevention plan, she had indicated that being around people who use drugs is a trigger for her.
that's true, she did. And then subsequent to that, asked father to leave the home. So again, I would just end with the citation from Adoption of Luke, which contemplates the fact that relapse is part of recovery, and as long as parents continue to engage in services, they should not be penalized to the degree of terminating their parental rights simply because they have relapsed.
Thank you.
Thank you, Your Honors.
Mr. Lavender.
Thank you, Your Honor, and I do represent the father in this case who, as he did at trial, is supporting the mother's position that the trial court was in error when it terminated her rights. And I'll pick up right where Attorney Driscoll-Weiss left off with, your questioning about forthcoming. I think there's no question that there's evidence that at times these parents were not forthcoming. With respect to the separation itself, it's correct. So I don't think that he refused completely to give a location. He initially had given a name of the person he lived with, I believe on the third day of trial. On the fourth day of trial, he said he lived on a street in Pittsfield, and he first said that the person he was living with did not want him giving that information out in court, which I don't think is unbelievable. And then he came back later and gave an address. It was speculated, I think, in the judge's findings that he had used that time to confirm that a friend would cover for him, but I think it's just as possible that he checked with the friend and said, I really think that I need to give this information, and the friend said, okay, give the information. And I think the judge is speculating when the judge made that finding that the separation was a sham. I think it's all speculation. There's not really any evidence in the record to support the conclusion that it was a sham, and she's speculating based off of things like the fact that mother drove him to court. Although he was living in Pittsfield where the court was, he didn't have a car. They said that they were still friends. So all of the evidence on that point was that they had separated, and there wasn't any evidence to counter it. There was just speculation. And I think also where the judge errs here is she kind of seems to be operating from a false assumption that there were only two options here, which is terminate mother's rights forever or send the child home and wash our hands of it. And that's not how the system works. And neither parent was advocating for that. The mother could have continued to be engaged with DCF. The court could have maintained oversight. They could have returned conditional custody on the condition that she continued to test positive and father stay out of the home. Another option, as my sister suggested, is the court could have found that mother was unfit at the time of trial, but not that there was sufficient evidence that she would be unfit into the future indefinitely. And I think on that point, the huge amount of progress this mother makes it very hard to say that she was going to be unfit forever when she had come so far. And if the judge had done that, the case would have been ripe for review and redetermination in December of 2022. Actually, mother also herself on the first day of trial offered to stipulate to her current unfitness, so a review and redetermination could have been as soon as September of 2022. So let's say that that's what happened. By September or December of 2022, there could have been much clearer evidence about whether this separation had happened and about whether it was going to last. If by December of that year, we had mother continuing to test negative, father staying out of the home, then the evidence could have supported a reunification, and the child could have achieved permanency actually a lot sooner than under the approach that the trial court happened. If it had gone the other way, and by the end of the year, father's in the home, they're both still testing positive for fentanyl, the evidence would have been even more overwhelming against mother. She might have entered an open adoption agreement, or she might not have appealed. So assumption, and it's raised by both the appellees, that it was in the child's best interest to achieve permanency by terminating mother's rights at that time. I think it overlooks that these cases can go in a lot of different directions, and actually continuing it in the way we're suggesting would have had a very good chance of achieving permanency for this child a lot earlier than it did. A couple of other points I want to raise. In addition, after the mother relapsed, and I think it's important to emphasize, there's an argument that was made that she tested positive in 12 out of 19 months of the child's life. But if we look at the order of that, it's almost all the first few months. Then from the summer of 22 to the end of the year, she's negative month after month. She has a relapse in January of 2020. I'm sorry, I was saying 21. I was saying 2022. It was from summer of 2021 to the end of the year, she was testing negative. Then she had a relapse in January of 2022 and another in March. After that, she did make changes. In addition to the separation with father, she testified that she obtained a sponsor at the direction of her program that she was in. And I think here the judge...
Those were the McDonald's employees, weren't they?
Yes, the McDonald's employees. And Your Honor, I think that the judge really incorrectly and unfairly did not credit that as a valid step. And the judge imputed her own understanding of what a sponsor is against... The judge basically said a sponsor is somebody from an agency with qualifications and training, and that's not in the evidence, and I don't know that that's correct. A sponsor is somebody who has previously had a substance abuse problem, who has recovered, and who wants to help other people. And the only qualification I know of, and again, it's not in the record, the only evidence in the record is that this was mother's sponsor. It's somebody who wants to help. And this is not a person, this is a woman who is starting alone. She's in a new state. She can't live with her parents because of the toxic relationship with her father. She can't live with her partner because of the substance issue that he presents. And she's in a new state. She's not going to have a lot of connections, and yet she had the courage to talk to her new coworkers and find somebody who was willing to help her. And she did testify that the program she was in did not require the sponsor to be somebody with any particularized training. I think they signed off on this sponsor. So I think it's unfair to sit here and condemn her that that was who she found. She did the best she could with what she had. And again, the standard is always current and future. It's not looking back. At the time of trial, she had had a relapse, but then she had made changes, and she had not tested positive since that time. The judge discredited both of the changes based off of speculation and imputing her own understanding of the term sponsor, which I don't believe is something the court can take judicial notice of, and discredited those changes and said she's not made enough progress and terminated her rights. And father would suggest that that was erroneous. Finally, just in conclusion, I do want to note, since father is not appealing his own termination of rights, he would request on remand that he be allowed to participate only, if the court remands, that he be allowed to participate only as to the child's best interest, but not as to his own rights. And that is supported by adoption of Douglas, 473 Mass 1024. It's not in the briefs, and father's standing wasn't challenged, but I did want to just note that.
Yeah. Thank you.
Thank you, judges.
Mr. Price.
Can you hear me okay? Good morning. May it please the court. Matthew Price on behalf of the Department of Children and Families. The department is asking this court to affirm the lower court's termination of mother and father's parental rights. There was ample evidence of the parents' unfitness at trial, and the trial court's findings were largely unchallenged. I'd like to briefly address father's argument first before mother's, which is to say father is not contesting his termination, and as far as his arguments are for mother's fitness, I would argue that he does not have standing to do that. Mother is represented and filed a brief. As far as the judge's decision, as far as finding parents unfit and terminating their parental rights, it was not an abuse of discretion. There was plenty of evidence to support that mother and father was unfit. But to focus on mother, this is not a case that took place in a snapshot at trial. This took place as a long movie reel of events that goes back at least as far as 2017, which is when mother began using Percocets and became addicted, later becoming addicted to fentanyl. When mother returned to Massachusetts, this is not her first child that she had removed. She's had 3 children previously removed. At least one, as far as I can tell from the evidence or the findings, was during her addiction to Percocets. This distinguishes, I think, the case from adoption of Catherine, where the court found an absence of history as far as the parents' inability to parent due to their drug addiction. This is where when her 3rd child was removed, while she was using Percocets, she said that she was not able to parent, she was not in a good state of mind. And I think that that distinguishes it from Catherine. As far as how her addicted affected this child, mother was using at least some kind of opiate in February 2020, around the time when she would have become pregnant with this child. In May of 2020, she began using methadone and trying to get help as far as her addiction. However, she continued to use opiates. When the child was born in November of 2020, mother tested positive for fentanyl as well as methadone. The child being born drug exposed or drug addicted needed to stay in the hospital for a month after in order to go through withdrawal before the child could be released.
Counsel, I'd like to jump ahead to future harm. I don't really think mother is contesting that there was substance misuse issues at some point. The question is future harm in my mind. So if we could jump to what other findings or what findings did the judge make that support that she's a future risk to the child based on the efforts that she seems to have made?
I think that the efforts that mother made was indicative of the deep hole that she was in and hadn't gotten out of. What the judge found was that she was involved in services. She was involved with a parenting group. She was involved with taking methadone. She was involved in therapy. And she continued to test positive for fentanyl. Fentanyl is a very difficult drug to overcome, and it's understandable. Her pattern at best was that she would have some time where she tested negative from fentanyl and still taking methadone, and then relapse. And I would, so what the judge had to find, I think, is more in line with adoption of ELANA, which is what acknowledged a pattern of behavior in a parent who's drug addicted, in this case fentanyl. And what the court found, I think, and it was not an abuse of discretion, it was correctly, was that a short period of months did not outweigh at least 5 years of opiate abuse. And there was no telling that she would, the judge found that mother said that she would stop using if she was reunified with the child. And there's no evidence that I think she could stop cold turkey and be able to do that. I think that that was a concern for the judge rightly. The child had been waiting 2 years for permanency, at least 2 years that mother had to work with to to show. And even if she was making progress, which the trial court acknowledged, much of the services that she did, it was not an abuse of discretion to find that that still wasn't enough to rely on.
Counsel, can I ask you about two evidentiary points, one of which father's attorney brought up? The judge seems to have made a finding regarding the sponsors that the mom had. And there was no evidence of what a sponsor actually is. Can a judge just take judicial notice based on prior cases what a sponsor is and that the employees were not good sponsors?
I don't know if the judge found them to be not good sponsors. What I understood was that there are criteria through affiliations that would make a person reliable to be a sponsor. As far as that goes, it seemed that those affiliations were not there for these two sponsors.
Okay. And how about her, and I'm not denying that, but that father was a trigger for her?
That father was a
trigger for drug use. Father certainly had supplied drugs for her in the past, but what evidence is there, because there is evidence that she had separated from him at least fairly recently, that he would continue to be a trigger?
Well, father was continually using. Father hadn't stopped using. However, separate, if he's out of the house, sort of best case scenario, they were still together. They were doing visits together. They were going to groups together. They were interacting together. Her preference was to continue to live with him, even though it seems on some level she recognized that being with active users was a trigger for her. I see I'm out of time. Thank you very much.
Ms. Morrison.
Good morning, Your Honors, and may it please the Court. Tara Morrison on behalf of the appellee child, and I am here today to ask this Court to join the Department and ask that the Court affirm the trial court's orders. To start, I just want to address, that of course in these cases the best possible outcome is a safe reunification with the family, with the parents. When that's not possible, the second best outcome certainly is a placement with a kinship home, where family members come forward and are willing and able to take custody of the child. And thankfully that is what has happened here. The child is in a kinship placement with the maternal aunt and uncle, mother's aunt and uncle, so the child's great aunt and uncle. This is the only home that the child has known since birth. And these are also family members that mother herself at trial acknowledged are, she, I think, testified that they were main supports in her life. And there was also evidence presented at trial that these family members would be willing to continue to facilitate a relationship between mother and child. And I think that the court took all of that context into consideration in making its best interest determination on behalf of my client. My client also has frequent contact with her maternal half-siblings who do live close by, and the pre-adoptive home has ensured that they continue to have a relationship. So in terms of the way that this case has shaken out, this is a child who is having frequent contact with various family members and is still a part of the general family unit, and hopefully and ideally in the future would continue to have a relationship with mother. Just to address the court's questions and arguments regarding the sufficiency of the evidence in terms of the future harm posed to the child if she were to be reunified with mother, I would also just like to point out some of the differences between this case and Catherine. And I think it is important to note just that in in Catherine, we're talking about a cocaine habit is how the trial court characterized those parents' substance use. Of course, the court could not have anticipated illicit drugs like street fentanyl, which is an incredibly dangerous drug. It's incredibly dangerous to children and users, and is in development. Even current understanding of its dangerousness, I think, is ongoing. I think the trial courts are tasked with balancing a sensitivity around substance use disorder and the fact that relapse is a part of recovery with the reality of what children experience when they're placed in the care of an unsafe caregiver who's struggling with a substance use disorder and trying to rely on that parent to provide a safe home. This is not a task that the court took lightly in this case, but instead acknowledged that relapse is part of recovery and it's fine in the judge's findings, and also that mother had made laudable efforts at the time of trial. But the reality also is that the mother had a very recent relapse, and most recent in a pattern of relapses. And if the court is looking to assess, the likelihood with which mother is going to continue to relapse, I think it was fair for the trial court to put the steps that mother had taken in the context of a recovery plan, and look to the fact that she continued to live with an active user up until 1 month before the close of evidence, and at trial was really unable to, her testimony did not reflect the fact that father was the one providing her with fentanyl, or that she was using fentanyl with him, and that's in direct contradiction to father's testimony that he was directly providing it to her and using it with her and encouraging her to use in the home. And so unfortunately, looking at the long landscape that is the reality of recovery for individuals experiencing a substance use disorder, the court was correct in concluding that these facts, put mother at perhaps the early beginnings of recovery. And the reality is that we have a child who, deserves permanency and is with a safe kinship placement, is developing appropriately, and does have an opportunity to continue to have a relationship with her mother through this kinship placement and the family.
By the end of the trial, though, it's fair to say that mother had been sober for 3 months, correct?
I believe it would have been approximately maybe 2.5 to 3 months, yes. And of course, that is, laudable efforts to mother on her journey to achieving sobriety. But the judge was also looking at that long-standing relationship with father and the, frankly, devastation that it had brought on mother's ability to achieve sobriety, and where mother testified that her not only living situation, but her romantic relationship with father terminated, I believe it was May 14th, and the trial concluded on June 14th. So she had had 4 weeks, according to her testimony, of both separation of that romantic entanglement as well as her cohabitation. It's a very short period of time to be developing more positive relationships, other support systems, for someone who has been perhaps codependent.
But despite being with the father during that period of time, she was able to maintain sobriety.
Yes, at least until that month where he...
The judge doesn't really make any finding regarding that. She talks about the fact that mom can't separate from father, but she doesn't talk about the sobriety that mom has even when she was with father, does she? Or does he? Sorry.
I don't believe, though, the court directly addressed that, although I could be incorrect. But the totality of the pattern of behavior that the court's looking at for mother, that she was living with father, did achieve months of sobriety, and then repeated relapses, it does provide evidence of a pattern that they were engaged in together, where father is, perhaps doing his best to support her sobriety, but also testified that he was bringing drugs into the home and encouraging her to use with him. So I think the evidence of the codependency is apparent, and the judge was correct to find likely to repeat. And in terms of the judge's credibility evaluation of the witnesses, I would just like to point out, this is soundly within the trial court's discretion to be assessing even without, absent any, counter evidence, the court is even just looking at how, the tenacity, the appearance, the form of the testimony, the witness's ability to be forthright with information, and, that was certainly lacking in terms of the parent's testimony, as well as the context of the separation occurring during trial, all supported the court's conclusion that it was perhaps not a permanent separation.
Okay, thank you.
And if there are no further questions, I'll rest up my brief. Thank you.
Thank you. Thank you all. With that, I'd like to thank my colleagues, our court officers, our court staff, our clerk's office, our law clerks, our excellent timekeeper. And with that, we'll stand in recess.